Item 1, contempt case criminal suo motu 1/2025.
They have filed their evidence on affidavit, possibly fix a date for cross-examination.
Mr. Date, both of you. August.
Will August be too late, Miller?
Let's try some time in the month of July.
July, huh?
Last.
Okay, no problem. Rajiv can have 24th board আছে না 28 29 let it be Milord 27th or 27th Milord. No. 27.
So Monday.
Oh. Then Milord 28 Milord. Yes, 28 Milord.
Preferably at 2.
Milord.
Preferably at 2.
Second half I'll be not there, Milord. That's why. Or else, Milord, 28, actually second half I'll not be there, Milord.
28 August.
Then 4th, Milord.
4th, 3 problems.
4th.
At 2.
Milord.
At 2. Third, Mr. T.J. Mahtal, Allied Senior Counsel, standing counsel of this matter, assisted by Ms. P. Sharma, Learned Counsel for the appellant. I have an applicant. For this court. He has submitted that affidavit. Evidence on affidavit of the witness number 1 has been filed. A copy thereof has been served to the respondent. Next. Accordingly, that the whatsoever Mr. K. N. Chaudhary, the Senior Counsel, assisted by Mr. N. Gautam, Learned Counsel for the respondent. Next, the contender is also present. Next, as agreed to by both sides, this is the matter for cross-examination of the witness on 4/8/2026. Preferably at in the second half. The senior standing counsel for the court. Please send a downloaded copy of this order to the concerned witness to be present. Next, this will go. Yeah. Mr. Chaudhary, Mr. Mahtal?
Yes.
Please wait, Sister Justice joined.
Very well. Lordship.
Please wait, Sister Judge will join.
No, that's a bit. Order information. Yes.
Division Bench, Item 1, Contempt case Civil 33/2026, Suranjita Hazarika versus Dr. Robi Kuta, IS, and 4 others.
May it please.
Yes.
This matter comes up pursuant to your lordship's order of 11th June 2026, when your lordship's, my lord, in view of a request made by my learned friend, my lord, had placed it for today. Well, my learned friend was continuing his arguments, my lord, in reply. On 26th March, when your lordship's, my lord, had a detailed hearing, my lord, kept it for 5th May, my lord. So my friend has to, my lord, continue his arguments. Only one point I wanted to point out, my lord, is that the order of 18th February 2026, my lord, remains unimplemented till date.
Yes.
Would, may I begin with Lordship and Ladyship's indulgence?
Yes, yes.
I'm grateful. So, Lordship, it's been a little while since the last date when Lordship, Ladyship would have heard me. I would, of course, be placing before Lordship and Ladyship's consideration that, first and foremost, the unconditional apology for any unintended misinterpretation, and there is no willful or deliberate non-obedience or disobedience with Lordship's orders. Now, Lordship, in this context, Lordship has passed 3 orders. They are detailed orders. I have filed already for the state its reply affidavit in opposition. The first order was of Lordship and Ladyship of 29/1/26. If Lordship and Ladyship would just open that for a minute.
Yes.
And Lordship may come that in para 2, my learned friend has argued about the non-compliance and willful disobedience of Lordship's judgment of 20th of June. Para 3, Lordship. It is submitted, and that is the submission of the other side, that there is a positive direction in the judgment and the order for reinstating the petitioner, and to make an endeavor to complete the departmental proceeding within the outer limit of 90 days. This positive direction refers to para 141 Roman 1. And my learned friend is arguing that this has not been complied with. So this is my first submission, that there is a positive direction on which my learned friend is relying. But our case is that is subject to certain fulfillment of certain conditions. That means it is not an unqualified, unconditional direction. It is a qualified direction subject to the fulfillment of certain conditions. I'm making my submissions. I'll make it good shortly. Is Lordship with me?
Yes, please proceed.
Grateful, Lordship. So my first submission being that the positive direction of para 141 Roman 1 is conditional and subject to fulfillment of certain conditions therein, within 141 Roman 1 and also conditional to other directions in para 140. So therefore, Lordship, they would need to first establish that they cross the thresholds as enumerated in Lordship's own directions in para 140. That's my submission. Now, Lordship, may I request Lordship and Ladyship to come to Lordship and Ladyship's order of 18th of February, because those directions are there. So I can then refer to that order and also the directions. 18th of February.
Yes.
Now, if Lordship may come to this para 3 of the said order, and Lordship may see para 140 of Lordship's judgment is duly reproduced. And what does para 140 say? Once Ladyship has it on page 3 of the order. Para 3. Accordingly, the appeal is partly allowed by setting aside the impugned judgment and order dated 18/3/20 passed by the learned single judge in writ petition 4198 and 48 connected writ petitions. Resultantly, the repellents are found entitled to the following reliefs. 1. The discharge orders in respect of the appellants herein are set aside. So, Lordship sets aside the discharge orders, but please mark, however, the relief is subject to the following. Now, Lordship has qualified the relief to 8 conditions within para 140. 1. And what is the first condition, which is the positive direction that my learned friend relies on? Roman 1 says, those appellants, including those who are here alleging contempt, who have completed their initial probation period of 2 years. So first, completing their initial probation of 2 years, and which means along with taking into consideration the maximum extendable probation period under the respective rules. So now there are 2 parts. Complete your initial probation of 2 years and taking into consideration the maximum period of probation. In our cases, in this case, it applies to 2 plus 2 equal to 4 years. And I'll show it just now. And she had not completed it. I rule 22(1) of the so-and-so, Lordship has considered all the rules. Then at the end, in the second last sentence, Lordship holds, are liable to be reinstated within a period of 50 days from the date of this judgment. Pause. So the threshold they have to cross before claiming relief under the positive direction in para 141 Roman 1, they have to establish that not only they completed 2 years of the initial probation, but also they are not foul of the applicable rules to the person here. That means they have to show they had completed 2 years as also the extendable period of 2 years for the probation to be complete in terms of what Lordship says, that who have completed their probation. Now, Lordship, there is a second direction in para 140. 1 Roman 7. And if Lordship, Ladyship would be pleased to turn the page and come to para 140, Roman 1, 7. If there are any appellants whose probation period has not been completed, they would not be entitled to be reinstated in service. So now what I argue, that Lordship's directions are clear, they are unequivocal, there is no scope for any confusion. The reinstatement is subject to, within 141 Roman 1, the rules completion of the initial period and the maximum period under the rules. And then in 141 Roman 7, if they have not completed their probation period, and here the word used is not initial probation period, it says probation period, i.e. initial plus extendable probation period under the rules, they would not be entitled to be reinstated in service. Pausing for a minute, Lordship, Ladyship. That is an expectation for us to establish. So my learned friend has to first establish in 141 Roman 1 that the initial period was completed of 2 years, and as per the applicable rules, his probation stands completed. And for the state, the obligation is under 141 Roman 7 to say and show and establish that they have not completed their probation, i.e. total probation, and hence cannot be reinstated. However, as Lordship has noted in para 141.7, it says, however, in respect of those appellants, the competent authorities in the government shall pass appropriate orders to withdraw their respective discharge order already passed and to substitute the said discharge orders with a simpliciter discharge order of not having found them fit for confirmation, so that no stigma is attached against them. This, Lordship, is what is the scope of the relief. Our case from the state's perspective, and of course, Lordship, we are not in review. In review, the state has only moved with regard to para 67 and 68 with regard to the statutory rules, because they were not under challenge, and we cannot have those rules disturbed by any observation within the judgment, because those rules are in force and it can create a future problem. Some people have filed review, and Lordship has already issued notice. It's a separate issue. My argument, Lordship, is noted in para 4, and that is clearly noted. It is submitted that in the said order, the court had taken cognizance of the completion of the initial probation period of 2 years of all the appellants, including the petitioner. Lordship is with me. Para 4 of the order of 18th of February on page 5, internal page 5.
Yes.
Yes, Lordship. So I'm just confirming that this is my submission. It is submitted that in the said order, the court had taken cognizance of the completion of the initial probation period of 2 years of all the appellants, including the petitioner, and taking into consideration the maximum extendable probation period under the respective service rules, directed reinstatement within a period of 50 days from the date of the judgment. Then what we say, it is submitted that though the case of the present petitioner falls within the scope of the ambit of para 141.1, the state has considered only the direction contained in para 141.7 and has passed the discharge orders. This is their submission, I'm sorry, Lordship, against several other appellants. So they are, in a way, arguing to sever direction under 7 with direction number 1. Our Roman 1, our cases on both folds, they cannot be entitled to any relief, because under 141 Roman 1, they have to establish that they have completed the total probation period. And under 141.7 Roman 7, we have to establish that since they have not completed their total probation period, they are not entitled for reinstatement. Now, Lordship may come to page 8, internal of Lordship's order, para 13, reproduces the rules. Para 13, Lordship, Ladyship. Now, this is Rule 21, Lordship, of the Transport Service Rules of 2003. And if Lordship, Ladyship would be pleased to see, 21 deals with probation and confirmation. Subject to availability of permanent vacancy in the respective cadre, a member shall be placed according to his seniority on probation against permanent vacancy for a period of 2 years before he is confirmed against the permanent vacancy. Provided, the proviso is very important, the probation period of probation may, for good and sufficient reasons, be extended by the appointing authority for any specified period not exceeding a period of 2 years. Therefore, under Rule 21(1), read with the proviso to Rule 21(1), the total probation period is 2 plus 2 equal to 4 years. Now, Lordship, see the second proviso. Provided further that the period of probation may be extended or dispensed with within any good or sufficient reason by the appointing authority. 2. A member placed on probation under Sub-Rule 1 shall be confirmed against a permanent vacancy subject to the following. A. He has completed... Lordship said something? He has completed the period of probation to the satisfaction of the appointing authority in accordance with Sub-Rule 1. Now, Lordship may note, there is no subjective satisfaction of the appointing authority. So now, for them to claim any relief under 141(1), they have to establish two things. A, completion of the probation of 4 years, 2 plus 2, and they have to show that for being in service, where is that satisfaction by the appointing authority? And there is a second requirement under Rule 21(2)(b). He has successfully undergone the training and passed the departmental examination, if any, prescribed by the government under Rule 80. So respectfully, Lordship, they would need to bring on record 3 things now before contempt can be alleged. Or even they can make, according to me, the misplaced argument.
Before you make that submission,
Lordship,
please have instructions as to whether in state of Assam, anywhere that examination has taken place in the first.
Yes.
fair enough, Lordship.
The second bite of the cherry.
No, but Lordship, respectfully, we are now under the rules. Lordship may pass a direction thereafter. But if someone comes here, then he will have to fight not under contempt, but file under parity a separate writ petition. And therefore point out that, excuse me, no one you've held it for, so I am entitled under that, provided, Lordship, respectfully, he or she has completed 2 plus 2 years.
No, in this case, the petitioner was not the only person to be appointed in transport service.
Yes, Lordship.
The same batch you have appointed others, so you can't single out a differential treatment for another. For only
I
one.
bow to that, Lordship. I bow. I'm not even, in fact, challenging what Lordship is saying. I'm merely pointing out that cause of action would not lie under writ. It would lie under writ, not lie under contempt. I will also have case laws to follow, Lordship. I am only making that limited point because my learned friend, who's a very able arguing counsel and a friend of mine, is, Lordship, very persuasive. So I have to demolish those persuasions also in terms of legal demolishing, Lordship, not in any other way. So that's my argument. Now, Lordship, let's request Lordship, Ladyship to take my affidavit in opposition. And Lordship, in any case, I must point out, and that is for Lordship's consideration, Ladyship's consideration, we have not singled out the petitioner here. We have treated everybody in the batch equally. If you have not completed your probation period, 2 plus 2, you are a probationer, and there's settled law, Lordship. I will be showing the judgment. Wasim Beg is a 3-judge bench. It clearly has laid down the law. I mean, the law laid down can't change. There's only an aspect of interpretation whether they fall within that or not. if Lordship, Ladyship have got my affidavit in opposition.
Yes, yes.
Yes, I'm so grateful, Lordship. So, just to make it very brief, Lordship, in para 4, we have said there is no intentional, deliberate, or willful act of disobedience. We have the highest respect for this honorable court, for any honorable court, and we are duty bound to comply with directions. In para 5, Lordship,
You have heard the interpretation. That if you have respect, that is okay. If you have greater respect, that means you are doubting the court. When you have greatest respect, it inversely settles that the court is perhaps not understanding anything.
my lips are sealed on this, Lordship, but I must say it's very witty of Lordship to say so. And Lordship, on a complete light note, I have learned something today. And now I stand educated in terms of a future proceeding. In terms of my arguing capacity, Lordship. So I'm actually bowing down to my learning today. Okay, Lordship, I have a request. If the learned court master can please also take my colleagues, allow them to enter the proceeding, Ankit Roy and Nimisha are there, Lordship, because they are seeing it on YouTube, which is slightly delayed. They are logged in. So if they are there, they also are in real time there, Lordship. We are all in different locations today. So it helps me also. I would request for that little indulgence.
Okay.
Ankit Roy and Nimisha Menon.
Okay.
I'm so grateful, Lordship. There, my friend is there. Thank you. So, Lordship, in para 5, Lordship, we have placed for consideration that we have complied with the directions in para 140.17. And Lordship may note, I have argued to that effect. What I've just kept in para 5, Lordship, I have duly argued that. Para 6, Lordship, we are making our case that no contempt lies, because actions have been taken, one, in good faith, Lordship, and second, more importantly, in compliance of Lordship's judgment or the law. Third, without any intent or intention. Now, that's very critical, Lordship, because mens rea will come to play a role, intention will come to play a role when I rely on the judgments of interference. Lordship, may just give me a moment. So, we have said, I apologize for that, Lordship. There is without intention of interference with the administration of justice. We have no intentions at all. An intention is important, Lordship, mens rea. So therefore, we say, Lordship, in para 6, there is no intentional, deliberate, or willful act, and hence no mens rea. And we finally, Lordship, what I said right at the outset, place our unconditional apology for an unintended misinterpretation, and therefore seek Lordship's and Ladyship's indulgence that the contempt may be discharged. Then, Lordship, I will not refer, of course, to the judgments in my affidavit of opposition. I'll refer to them in a separate compilation. We have, Lordship, on page 229, para 7, just pointed out what I've argued, that the compliance of the directions at para 140 have been undertaken by the state. What I've argued, Lordship, in terms of para 141, Roman 1, and para 141, Roman 7. And therefore, Lordship, in para 8, we complete that argument to say that only those appellants, including the present petitioner, would be eligible for reinstatement in service only if they have completed the initial probation period as well as the maximal extendable probation period, the 2+2 rule. That, Lordship, we have reproduced para Rule 21. I have already read it. It was reproduced in Lordship's order. Then, Lordship, is the law. We are not going to refer to it yet. I will come to it in a separate compilation. If Lordship, Ladyship can come to para 11. Page 233. And Lordship, in para 11 is a chart, a table. that the date of appointment is given, Lordship, Ladyship may note, 15/10/2016. The date of completion of the initial probation period of 2 years is 14/10/2018. The date of discharge is 21/1/2019. And the 4 years, which is under the rule 21, which would have got completed 4 years, would have been 14/10/2020. So, Lordship, Ladyship, the state places for your consideration that they have not, as per the dates and as per the facts, completed. She has not completed 4 years. She was discharged even before 2.5 years of her service was completed, her probation. So therefore, Lordship, we have placed that table for easy reference. Then Lordship and Ladyship may for a moment come to page 236. I just wish Lordship, Ladyship to know what is our next ground of arguments, and then I'll go to the judgments. This is a without prejudice argument, Lordship, that the contempt petition would not be maintainable when the order on which contempt is alleged provides scope for different interpretations. So I just wished Lordship and Ladyship to note that, because that would become relevant when I refer to judgments. So if there is scope for interpretation, then contempt will not lie. I will also, Lordship and Ladyship, argue on case law that if they are dissatisfied with the discharge order for any reason, that also will not lie in the contempt jurisdiction, because this is not an execution equivalent. They would have to file a fresh cause of action. Being a fresh cause of action, they would need to file a fresh petition. And last but not least, Lordship, contempt. My learned friend and his client would be in the nature of an informer, bringing it for consideration for Lordship and Ladyship's consideration that there is an allegation of contempt. I have to satisfy that that the allegation of contempt is not correct. There is no intention to willfully disobey any of Lordship's directions. And after that, it is for Lordship and Ladyship to consider whether my arguments will hold water or not. So if Lordship, Ladyship, we have a compilation of judgments. May I request Lordship, Ladyship to take that compilation? And come to page 1. That, Lordship, Ladyship, is that 1998 judgment. We are handing it over, I think.
We don't have that compilation.
I am sorry, Lordship. My learned colleague Dipankar should have it. Would Lordship give us a moment? Mr. Roy will just be checking on it. May I read the SCC citations, if that would help, Lordship, for the time being?
Yes. You just give the citation so that.
I'm just giving the first citation, and in the meantime, my colleague will give the citation of the other judgments. The first is 1998, 3 SCC 321. Wasim Beg versus State of UP. 1998, 3 SCC 321. I'm sorry, Lordship, that they were not available. We'll organize.
State of Bihar.
It's State of UP. 1998, 3 SCC 321. Wasim Beg versus State of Uttar Pradesh.
Yes.
Has Lordship got it?
Yes.
So, Lordship, this is by Justice Sujata Manohar and Justice Vadava. We may just come, Lordship. This is a very interesting case. Just from the basic facts, I won't read all the paragraphs. In this particular case, just for knowing it, because this is service law and this issue of probation and completion of probation, deemed confirmation, all kept coming up.
Yes, if I remember correctly, is case on confirmation at the end of probationary period.
Paragraph 76 at page 106, the Lordship have considered in the judgment.
No, Lordship has considered all. In fact, we kept all our judgments. I am only for refreshing. This is not my argument on contempt. It's merely in terms of refreshing the point on confirmation, deemed confirmation.
Yes, yes.
That's all, Lordship.
This
So,
paragraph.
Lordship, just may note basic facts. I'll take Lordship through para 1, 2, 3, 4 without reading them. That Lordship, the appellant here was an assistant manager in the UP State Leather Development Marketing Corporation, 1774. In 78, Lordship, he was appointed as a divisional manager. Now, Lordship, in para 5, 7 years later, he's terminated. That is what is interesting in this case. He, Lordship, then in para 8, filed a writ petition. And in para 9, the High Court upheld the termination. Lordship, they found the hard copy. I believe my learned colleague has just pointed out. Would Lordship like to take that compilation, Ladyship?
Okay, continue his.
Okay.
his thing.
Okay. So, para 9, the High Court upheld the termination. Now, if Lordship, Ladyship can come to para 15.
If you can send the what do you call the list of citations to the postmaster at Itanagar, my sister would get the books in the meantime.
As for the book.
Okay.
Oh, I didn't realize Lordship is sitting in Itanagar.
Yes, yes. I've got the book.
Sister is sitting.
I must say, this is a very national hearing. Lordship is in Itanagar.
Hearing.
Yes, Lordship. Lordship is in Itanagar. Ladyship in Gauhati. My learned friend there. I'm in Mumbai. My colleagues are in different parts of the country.
Sister is at Itanagar. I am in Gauhati.
Acha, Ladyship is in Itanagar. Okay, you're in Gauhati. My very national Lordship. What integration on GC? Para 15. Whether an employee at the end of the probationary period automatically gets confirmation in the post, or whether an order of confirmation or any specific act on the part of the employer confirming the employee is necessary will depend upon the provisions in the relevant service rules relating to probation and confirmation. There are broadly two sets of authorities of this court dealing with this question. In those cases where the rules provide for a maximum period of probation, beyond which probation cannot be extended, not applicable to us, this court has held that at the end of the maximum probationary period, there will be a deemed confirmation of the employee unless the rules provide to the contrary. Now, Lordship may just note that the state of Punjab versus Dharam Singh in the next sentence was a constitution bench judgment. So this is settled law. We don't need to go down that route because this is not applicable to us. Para 16. However, even when the rules prescribe a maximum period of probation, if there is a further provision in the rules for continuation of probation beyond the maximum period, the courts have made an exception and said there will be no deemed confirmation in such cases and the probation will be deemed to be extended. So essentially, Lordship, if the rules provide, as in this case, 2 + 2, and there is no order of confirmation, it will not be deemed that the employee is confirmed in service. It will be deemed that the probation continued. That is not also in dispute here because the probation has been continued, extended. In this category of cases, we can place Shamsher Singh versus State of Punjab, which was a decision of the bench of 7 judges, where the principle of probation not going beyond the maximum period fixed was reiterated, but on the basis of the rules which were before the court, this court held, which was on those rules, that the probation was deemed to have been extended. A similar view was taken in other courts, Lordship, in other judgments, in which we have also relied upon, Satya Narayana Thea. Although the rules prescribed that the probationary period should not exceed 2 years, and an order of confirmation was also necessary. The termination order was issued within the extended period of probation. Hence, the termination was upheld. Now, the second line of cases is para 17. The other line of cases deals with where the maximum period, there is no maximum period prescribed for probation. That won't be applicable to us, but Lordship may just note it because this deals with the subject. Now we can, Lordship, having reiterated that, let's shift to the law on contempt, Lordship, which will be the next case we are relying on, and the citation being, Ankit, have you sent the citation?
Yes, sir. The hard copy is there, sir.
No, but it's citation to ladyship in will need it, na?
I'm sending it.
Please, Ankit, send the citation. Lordship was specific on that. I apologize again, Lordship. I'm sorry for that. Ladyship, just bear with us for a minute. But the second citation is 2023 17 SCC 545. A recent judgment of Justice Pardiwala and Justice Manoj Mishra, 2023 17 SCC 545.
It's part of my compilation, your lordships can take it. And Marto, will you please hand over the compilation to our ladyship? Yeah,
This is the
my friend
compilation.
Marto Kato is there in Itanagar. He will hand over the compilation. That's the second judgment my friend is relying upon.
Balwant Bhai, Soma Bhai Bhandari.
Balwant Bhai, Soma Bhai Bandar.
This lordship, ladyship deals with a land issue. In this, what happened, lordship? There was a direction of status quo and the land was sold. That's the background. But lordships in the Supreme Court have dealt with the contempt jurisdiction, and there's several things there that I would like to place for lordship and ladyship's consideration. Internal page 556 is where para 1, 2, 3 are the initial facts. Just to 4 sentences on it and we'll go to the law.
Yes.
So, Lordship, just to point out that I mentioned that there was a status quo order and the land was sold. So, in para 2, it merely says that 2 appeals under section 19 of the Contempts of Court Act were filed and 1 civil appeal was filed by the purchaser of the land. And what is critical to note in this judgment, Lordship, is para 3. That the appellants of the 2 statutory appeals have been held guilty of contempt by the High Court of Gujarat for their deliberate and willful disobedience of the undertaking given to the court. Now, Lordship needs to make a note of that. In this case, the facts related to an undertaking to the court. And hence, any finding is qua that. That if you give an undertaking, and after giving an undertaking, you don't comply. Has ladyship got the judgment?
Yes, yes.
Grateful.
Yes, I've got it.
Grateful. So then, Lordship, this court would, obviously, or any court would hold the person guilty of contempt. So I'm not relying on the facts because there is no undertaking in my case. I'm relying on the law that lordships have reiterated or asked or laid down in terms of what would be the contempt jurisdiction. That is why, Lordship, para 3 was critical. And if now Lordship, ladyship can come straight to para 43, which is internal page 574. And while I'm reading my paras, if my learned friend feels I should read another para to save on the court's time, I would happily read that on his behalf. Para 43, internal page 574.
Yes.
It behoves the court to act with great circumspection as possible making all allowances for errors of judgment. So lordships have held that contempt jurisdiction must also make every allowance for errors of judgment on behalf of the alleged contemner. It is only when a clear case of contemptuous conduct, not explainable otherwise, arises that the contemptor must be punished. Punishment under the law of contempt is called for when the lapse is, please mark, deliberate and in disregard of one's duty and in defiance of authority. So 3 requirements. And that will come on to evil motive later. Contempt proceedings are quasi-criminal in nature, and the standard of proof is the same as in other criminal cases. The alleged contemptor is entitled to the protection of all safeguards and rights, including the benefit of doubt. So this is my first leg of argument in terms of law. Lordship, ladyship may now see para 46. The constitutional bench of this court and Supreme Court Bar Association, while discussing the ambit of powers under 1971 Act and the principles to be followed while punishing a party held as under para 28, an analysis of the above provision shows that subsection 1 of section 12 provides that in a case of established contempt, so there has to be an establishing of the fact that it is deliberate, it is willful, it is driven by mala fide intent, and there is no error, there cannot be any doubt that such act was done being deliberate, willful, and with a mala fide intent. The contemptor may be punished. Then lordship, bottom of the page, just above the last paragraph 6, it refers to Pushpa Ben versus Narayan Das Badiani, and in para 6, the court held, a close and careful interpretation of the extracted section leaves no room for doubt that the legislature intended that a sentence of fine alone should be imposed in normal circumstances. So now there are 2 parts, lordship. First, establishing that there is willful, deliberate, and intentional, which means with intent, disobedience of the court, where there is no scope for any interpretation and allows for errors in judgment. After that is established, the choice is about fine or punishment. Now, lordship, we can go straight to para 49. My lordship, I'll read on page 576. I will read para 42, which is the quoted paragraph, lordship, of the judgment, which is under placidum G, bottom of the page, on page internal page 576. The purpose of contempt jurisdiction is to uphold the majesty and dignity of the courts of law. It is an unusual type of jurisdiction combining the jury, the judge, and the hangman. And it is so because the court is not adjudicating upon any claim between litigating parties. This jurisdiction is not exercised to protect the dignity of an individual judge, but to protect the administration of justice from being maligned. In the general interest of the community, it is imperative that the authorities of the court should not be imperiled, and there should be no justifiable interference in the administration of justice. Please mark, it is a matter between the court and the contemptor, and the third parties cannot intervene. It is exercised in a summary manner in aid of the administration of justice, the majesty of law, and the dignity of courts. No such act can be permitted which may have the tendency to shake the public confidence in the fairness and impartiality of the administration of justice. So that's the general law. Bottom of the page, 49, what is willful disobedience? In order to decide whether the appellants are guilty of civil contempt, we would like to refer to section 2B, which is the definition section. Turn the page, lordship, ladyship. On the top, civil contempt means willful disobedience to any judgment, decree, direction, order, writ, or any proceeding of a court, or willful breach of an undertaking given to a court. Now, this does not apply to us, but in this particular case, which I'm reading, an undertaking was given to the court. Hence, the facts would be distinguishable. 50. In Black's Law Dictionary, defines willful as and willful being proceeding from a conscious motion of the will, voluntary, knowingly, deliberate, intending the result which actually comes to pass. Next para, premeditated, malicious, and please mark, done with evil intent or with a bad motive or purpose. Unlawful without legal jurisdiction. I would respectfully say, Lordship, there is no evil motive. There, it is not premeditated, it is neither malicious, and there is no bad motive. We are implementing what we believe is the clear directions in para 141 Roman 1 read with 141 Roman 7. Then, Lordship, bottom of the same Black's Dictionary, an act of or omission is willfully done if done voluntarily and intentionally with the specific intent to do something which law forbids, or with the specific intent to fail to do something that the law requires to be done. What that is to say, with bad purpose either to disobey or to disregard the law. It is a word of many meanings, with its construction often influenced by context. Para 51. Lordship is a 3-judge bench of Niaz Muhammad versus State of Haryana. Reproduces para 9. On the third sentence, it starts, where the contempt consists, Ladyship may must see it also, where the contempt consists in failure to comply with or carry out an order of a court made in favor of a party, it is a civil contempt. The person or persons in whose favor such order or direction has been made can move the court for initiating proceeding for contempt against the alleged contemptor with a view to enforce the right flowing from the order or direction in question. The Lordship, there are 2 directions. Direction 1, Roman 1, and direction Roman 7. So therefore, Lordship, I will show later a case that 2 interpretations means no contempt. But such a proceeding is not like an execution proceeding under the Code of Civil Procedure. The party in whose favor an order has been passed is entitled to the benefit of such order. The court, while considering the issue as to whether the alleged contemptor should be punished for not having complied with and carried out the direction of the court, has to take into consideration all the facts and circumstances of a particular case. That is why the framers of the Act, while defining civil contempt, have said that it must be willful disobedience to any judgment, decree, direction, order, writ, or any process of court. Before a contemptor is punished for non-compliance of the direction, the court must not only be satisfied about the disobedience of such judgment, decree, direction, or writ, but it should also be satisfied that such disobedience was willful and intentional. So 2 things to be established, the threshold being high, since it is a quasi-criminal proceeding in that sense, that it has to be deliberate and it should be, disobedience should be willful and intentional. The civil court, while executing a decree against the judgment debtor, is not concerned and bothered whether the disobedience to any judgment or decree was willful. Once a decree has been passed, it is the duty of the court to execute the decree, whatever may be the consequences thereof. But while examining the grievance of a person who has invoked the jurisdiction of the court to initiate the proceedings for contempt for disobedience of its order, before any such contemptor is held guilty or punished, the court has to record a finding that the disobedience was willful and intentional. Para 53, Lordship, refers to Ram Kishan versus Tarun Bajaj, a 2014 judgment. Just below placentum F, after the italics, the sentence begins, willful acts does not encompass involuntary or negligent acts. So if there is negligence also, that is not contempt. The act has to be done with bad purpose or without justifiable excuse or stubbornly, obstinately, or perversely. Willful act is to be distinguished from an act done carelessly, thoughtlessly, heedlessly, or inadvertently. Lordship, Ladyship, again read with para 43, which says you have to make allowance for all allowances of every allowance has to be taken into consideration, including errors of judgment, which includes all of what I've read, Lordship, which is held by the Supreme Court, acts which may be careless, thoughtless, heedless, or even inadvertent. It does not include any act done negligently or involuntarily. The deliberate conduct of a person means that he knows what he is doing and intends to do the same. Therefore, there has to be a calculated action with what? With evil motive on his part. Respectfully, Lordship, there is no evil motive in complying with Lordship's directions. Even if there is a disobedience of an order, but such disobedience is a result of some compelling circumstances under which it was not possible for the contemptor to comply with the order, the contemptor cannot be punished. Respectfully, Lordship, Direction 141, Roman 7 cannot be disregarded. It is specific. So while considering Lordship's qualified and conditional direction in para 141, the state is obligated and required to look at the directions in para 141, Roman 1 and Roman 7. Para 54. The aforesaid decision as also holds as under, this is Ramkishan's case, Lordship, which is of 2015. The contempt jurisdiction conferred onto the law courts power to punish an offender for his willful disobedience, contumacious conduct, or obstruction to the majesty of law. For the reasons that respect and authority commanded by the courts of law are the greatest guarantee for an ordinary citizen that his rights shall be protected, and the entire democratic fabric of society will crumble down if the respect of the judiciary is undermined. Undoubtedly, the contempt jurisdiction is a powerful weapon in the hands of the court of law, but that by itself operates as a string of caution, and unless thus otherwise satisfied beyond reasonable doubt, it would neither be fair nor reasonable for the courts to exercise jurisdiction under the Act. The proceedings are quasi-criminal in nature, and therefore standard of proof required in these proceedings is beyond reasonable doubt. Para 64, Lordship, at page 584. Ladyship may also please come to para 64. This relies on a Delhi High Court division bench. As held by the Delhi High Court and Suman Chadda, this is Lordship of 2018. In the case of reasonable doubt, it is not fair and reasonable for the courts to exercise jurisdiction under the Act, for the proceedings are quasi-criminal in nature, and the standard of proof required in these proceedings is beyond all reasonable doubt and not mere probabilities. Thus, please mark this, Lordship, this is very critical for us. In cases where two interpretations of an order are possible, and if the action is not contumacious, contempt proceedings are not maintainable. And for this purpose, the order must be read in entirety. My learned friend can't restrict it only to para 141, Roman 1. My learned friend has to read it in entirety, including the direction in para Roman 7. The court noted that there is a difference between standard of proof and manner of proof in contempt proceedings. Contempt proceedings are sui generis in the sense that strict law of evidence and code of criminal procedure are not applicable. However, the procedure adopted in the contempt proceedings must be fair and just. The Supreme Court, a Delhi High Court decision in Suman Chadda referred above, was challenged before this court. The decision of the court is reported, and then Lordship, it goes on to uphold that decision. We may come to Lordship, Ladyship, to para 97 at internal page 596. Para 97.
Yes,
May I read, Lordship?
yes.
We may also be pertinent to refer to and rely upon the decision in D.N. Taneja versus Bhajanlal, older judgment of 1988, whereunder it was held that in contempt proceedings there are only two parties, the court and the contemptor. The court held as under, a contempt is a matter between the court and the alleged contemptor. Any person who moves the machinery of the court for contempt only brings to the notice of the court certain facts constituting contempt of court. After furnishing such information, he may still assist the court, but it must always be borne in mind that in a contempt proceeding, there are only two parties, namely the court and the contemptor. It may be one of the reasons which weighed upon the legislature in not conferring any right of appeal on the petitioner for contempt. The aggrieved party under section 19(1) can only be the contemptor who has been punished for contempt of court. It's just merely lordship. I have argued that assistance lordship can always call upon. But finally, it comes to lordship and ladyship determining whether there is a willful act, an intentional act with evil motive. It's not an inadvertent, it's not a careless, it's not a heedless act in that sense. Then lordship para 99 deals with the concept of apology. Where lordship, it has reproduced basically section 12. And it says that if the apology is bona fide, the contemptor may be discharged. Next, lordship para 100. Section 12 of the 1971 Act provides for the punishment of contempt. Proviso to this section states that the accused may be discharged or punished, or the punishment awarded may be remitted on the apology being made to the satisfaction of the court. Explanation to this says that the apology shall not be rejected merely on the ground that it is qualified or conditional if the accused makes it bona fide. Therefore, what is required of this provision is that the apology, which is either qualified or conditional, made by the alleged contemptor shall be not disregarded if the same, in the opinion of the court, is made bona fide. Para 102. We may take judicial notice of the fact that with all our humility at our command, that over a period of time, the courts have shown undue leniency and magnanimity towards the contemptors. Now, lordship, this is relevant in the facts to go through. And I am pointing it out because I believe my learned friend would also perhaps want to rely on this para. So therefore, lordship, it says this lenient attitude as shown by the courts over a period of time has actually emboldened, please mark, unscrupulous litigants to disobey or commit breach of the order passed by any court or any undertaking given to the court with impunity. Now, I read para 3 only to reiterate. This is a specific case of an undertaking. We are not that. Hence, the punishment for contempt that has been invoked and the rejection of the appeal by the Honorable Supreme Court is in that context. Para 103. The litigants proceeded for contempt of court have realized that they have a very potent weapon in their hands in the form of an apology. Take, for instance, the present case itself. What do the appellants want us to do? The appellants want this court to accept their apology and set aside the order of punishment and sentence passed by the High Court. There ought not to be a tendency of the courts to show compassion when disobedience of an undertaking or an order is with impunity with total consciousness. We don't fall in that respectfully, lordship. There is no undertaking bias. There is no disregard of an undertaking bias, lordship. On the contrary, we are making our case that we have duly complied with the directions in para 140, Roman 1, read with Roman 7. Lordship, we may go to the next case.
Please read para 117.
Sure, I will come to 117.
Grateful.
No, of course, Arnab, we'll save time of the court. Anything. We may summarize our conclusion, final conclusion as under. We hold that an assurance in the form of an undertaking given by a counsel advocate on behalf of his client to the court, the willful breach or disobedience of the same would amount to a civil contempt as defined under the Act. So an undertaking given even by an advocate would amount to contempt. 1.2. There exists a distinction between an undertaking given to a party to the list and an undertaking given to the court. An undertaking given to a court attracts the provision of the 1971 Act, whereas an undertaking given to a party to the list by way of an agreement of settlement or otherwise would not attract the provisions of the 1971 Act. In the facts of the present case, we hold that the undertaking was given to the High Court, and the breach of disobedience would definitely attract the provisions of the 71 Act. 3. Although the transfer of the suit property pedente lite may not be termed as void ab initio, yet when the court is looking into such transfers in contempt proceedings, the court can definitely declare such transactions to be void in order to maintain the majesty of law. Apart from punishing the contemptor for his contumacious conduct, the majesty of law may demand that the appropriate directions be issued by the court so that any advantage secured as a result of such contumacious conduct is completely nullified. This may include issue of directions either for reversal of the transactions by declaring such transactions to be void or passing appropriate directions to the authorities concerned to ensure that the contumacious conduct on the part of the contemptor does not continue to inure to the advantage of the contemptor or anyone claiming under him. 4. The beneficiaries of any contumacious transaction have no right or locus standi to be heard in the contempt proceedings on the ground they are bona fide purchasers of the property for value without notice and therefore are necessary parties. Contempt is between the court and the contemptor, and no third party can involve itself in the same. 5. The apology tendered should not be accepted as a matter of course, and the court is not bound to accept the same. The apology may be unconditional, unqualified, and bona fide. Still, if the conduct is serious, which has caused damage to the dignity of the institution, the same should not be accepted. There ought not to be the tendency by courts to show compassion when disobedience of an undertaking or an order is with impunity, with total consciousness. In the result, the appeals fail. I would respectfully argue, Lordship, they won't apply to us because we do have the directions in 141, which are specific, as also in 141.7. However, my learned friend may wish to argue otherwise, which I'm sure he will in the rejoinder. May I, Lordship, request Ladyship and Lordship to come to page 87, Lordship? I'm sorry, to the second judgment, Lordship. The third judgment, actually, which is T.C. Gupta versus Bimal Kumar Datta, 2014, 14 SCC 446. And Lordship, this was before the then Chief Justice and Justice Gogoi. Lordship, at page 448. I'm sorry, that's the internal page 448, where the judgment starts, which is para 1. Now, this is, Lordship, a land matter. I will, of course, Lordship, just give the basic facts and go to para 10, which is the relevant. Lordship, this is 2014, 14 SCC 446.
Yes.
Lordship, Ladyship. So, Lordship, basically, para 1, by order dated so-and-so, the High Court of Punjab and Haryana has found the appellant guilty of commission of contempt in respect of an order dated so-and-so, passed in so-and-so. Consequently, the appellant was summoned to appear before the High Court for hearing before the pronouncement of order on the punishment to be imposed. Aggrieved, the present appeal has been filed. Now, Lordship, in this particular case, para 4 will show you that there was an order of status quo. On 18/8/2011, the following order was passed by the High Court. Notice for the date is fixed. Mr. So-and-so, Additional Advocate General, present in court, accepts notice. In the meanwhile, there will be status quo to the allotment as on today. So it was related to land and allotment. Para 10 will make everything clear. We don't need to read the detailed facts. The terms of the order of the High Court dated 18/8/2011, the averment statements made in the contempt petition and the reply thereto on behalf of the appellant, as well as the subsequent facts placed before us, have received our due and anxious consideration. The interim order of the High Court has directed status quo to be maintained in respect of all allotments of land. Admittedly, no allotments have been made by the appellant or any other authority. A contempt action being in the nature of quasi-criminal proceedings, the degree of satisfaction must be reached by the courts to hold a person guilty of commission of contempt would be akin to what is required to prove in a criminal charge, namely proof beyond reasonable doubt. Please mark, Lordship. The order of the court in respect of which violation is alleged must therefore be clear, unambiguous, and unequivocal. Has Lordship got that?
Yes.
The order of the court in respect of which violation is alleged must therefore be clear, unambiguous, unequivocal, and defines thereof must be apparent on the very face of action which a contemptor is charged. An interpretation of the terms of the court order in respect of which disobedience is alleged would not be appropriate while dealing with a charge of contempt. Such a charge cannot be brought home by unraveling the true meaning of the court's order by a subsequent order when there is an apparent ambiguity, lack of clarity, or dichotomy in the initial order. Now, Lordship, I'm not arguing dichotomy in the order. I'm not arguing lack of clarity. I am merely relying on the fact that an interpretation is required of the directions in para 141. When you see the directions that are subject to Roman 1 to 8 and Roman 1 and 7 have to be read together, and the actions of the state is clearly for that. Would Lordship, may I go to the next judgment, Lordship?
Yes.
This, Lordship, is an order 2009 17 SCC 645. 3-judge Lordship, Ladyship, 2009 17 SCC 645. Justice Rajendra Babu, KG Balakrishnan, and Venkatramana Reddy. Short order, Lordship. Para 1. Once Lordship has it, may I read?
Yes.
In a writ petition filed under Article 226 of the Constitution, an order was passed in civil order number so-and-so in the matter of so-and-so. The High Court made an order to the effect directing the consideration of the cases of the petitioners therein in terms of the National Volunteer Force Act and the rules framed thereunder to be employed on rotational basis. Now, Lordship, this relates to all of that. I'm not getting into the basic facts. It relates to appointments in the National Volunteer Force, the rules in which, and finally in para 7, in para 8 and 9. On the ground, what we wish to rely on is clear in these paras. On the ground that the order made by the High Court on the writ side is not complied with, a complaint was filed in the contempt jurisdiction. Unless there is willful disobedience to the order by the court, it is very difficult to conceive a situation where the High Court could hold a party to be guilty of contempt. In the present case, the order made by the learned single judge in respect of the complaint, in respect of which the complaint was made, is that the authorities will have to act, please mark, in terms of the statute and rules in regard to employment, and in this specific case, on rotational basis and their continuation in absorption. That is the substance of the order of 27/90/88. Where the statute and rules have been complied with or not, whether the statute and the rules have been complied with or not, whether the complainants concerned fulfilled the necessary qualifications as prescribed in the statute or rules or not, are all matters in respect of which there could be a serious dispute. In such matters, it could not be clearly stated that the parties concerned had acted willfully in contempt of the court. In that view of the matter, we think the High Court is not justified in holding that the appellants were guilty of contempt. Respectfully, there is a dispute between the interpretation of para 141 read with Roman 1 and Roman 7. Our understanding, as we have seen the order to be unambiguous in our respectful submission, to be specific, to direct us to do something, we have done so. My learned friend believes that we have not done so in terms of the interpretation of the order. That is a matter of dispute. It can't be raised in the contempt jurisdiction. Respectfully is what we are saying, relying upon this order. Para 9. Further, the High Court could have given certain clarifications in regard to the implementation of the order made by the High Court on writ side after giving due opportunity to all concerned. If the High Court felt that the order of the writ jurisdiction application was not properly interpreted or understood by the authorities concerned, but it could not have said, without reference to the relevant rules and factual details, that the appellants should purge the contempt by absorbing the petitioners in regular establishment without insisting on any test in view of their long and satisfactory service. And therefore, Lordship, that relief was granted. It was not appropriate to have passed the contempt order. Next judgment, Lordship, is citation is 1996, 6 SCC 291. 1996, 6 SCC 291, 3-judge, Justice Ramaswamy, Faizanuddin, and G.B. Patnaik. It's an order, Lordship. We may come to para 3. 3 and 6. May I, Lordship, start?
Yes.
Grateful. These appeals by special leave arise from the order of the division bench dated so and so. The facts are not in dispute. The controversy relates to the preparation of the seniority list of the engineers in Rajasthan Civil Engineering Services Public Health Branch. In writ so and so by order dated so and so, the DB of the High Court declared the seniority list prepared with retrospective effect in terms of the amended rules as unconstitutional. It accordingly quashed the list and directed preparation of the seniority list afresh to determine the inter se seniority on the basis and to grant promotion to the appellants within the specified time. The same order came to be reiterated by order of another division bench dated so and so in writ petition. It was further reiterated that by the order dated so and so, when the seniority list came to be prepared, the contempt proceedings were initiated under section 12. The learned single judge, on consideration of the merits of the seniority, held that the respondents had not willfully disobeyed the orders of this court. Then obviously, Lordship, the DB held that it was so. Para 6. The question then is whether the division bench was right in setting aside the direction issued by the learned single judge to redraw the seniority list. Lordship may come to placetum F, Lordship, Ladyship. On the right-hand side, the word is, the question is whether seniority list under 1991. The question is whether seniority list is open to review in a contempt proceeding to find out whether it is in conformity with the directions issued by earlier benches. It is to be seen that once there is an order passed by the government on the basis of the directions issued by the court, there arises a fresh cause of action to seek redressal in an appropriate forum. The preparation of the seniority list may be wrong or may be right, or may not be in conformity with the directions. But that would be a fresh cause of action for the aggrieved party to avail of the opportunity of judicial review. But that cannot be considered to be willful violation of the order. After re-exercising the judicial review in contempt proceedings, a fresh direction by the learned single judge cannot be given to redraw the seniority list. In other words, the learned single judge was examining the jurisdiction to consider the matter on merits in the contempt proceedings. It would not be permissible under section 12 of the Act. Therefore, the division bench has exercised the power under so and so being an order, etc. So, Lordship, I'm making 3 submissions. Number 1, similar to the seniority list here, there was a discharge order. That discharge order, Lordship, had clearly set aside subject to certain directions in para 141. We have complied with those directions and issued a fresh discharge order. Hence, Lordship, we would argue that there is a fresh cause of action, and that fresh cause of action cannot be invoked through the contempt jurisdiction of this honorable court. Whether, and as lordships have held in this order, whether our order is wrong or right, whether it correctly looks at lordship's direction or not. Because respectfully, our cases, we have complied with the directions which are specific, and we have complied in letter and spirit. That is our case. Next lordship, next judgment is a Calcutta High Court judgment, lordship. Citation is 1987 SCC Online Cal 73. 1987 SCC Online Cal 73. I'm very grateful, Lordship and Ladyship, for this holding this special bench. And despite Lordship and Ladyship being in different benches today, and I'm going to be concluding my arguments very shortly. I have only one or two judgments left to show. Placed for your consideration in our affidavit in opposition that we also have a without prejudice argument, and that without prejudice argument was that the contempt is not maintainable when different interpretations are possible. So that last part I'm now dealing with. Lordship, Ladyship has the judgment?
Yes.
Yes. So this I'll need to read the facts a little bit. The appeal is under section 19(1) of the Contempt Act, directed against so-and-so judgment. Lordship para 2 simply says that the employee was in the Post and Telegraph Department. In the fifth sentence, it says in 1974 in July, he was promoted on temporary basis. Then about 5 sentences below, in 1975, in March, he was reverted to the post of the Inspector RMS and was transferred to Howrah RMS. Aggrieved by the said order, the respondent made a number of representations to the higher authorities for its revocation but failed. The respondent then moved an application under Article 26 of the Constitution, challenging the order of March, praying for appropriate writs. Rule Nisi was issued on 17th of September 1975, and an order was passed maintaining status quo as on that day. Para 3. Alleging willful disobedience of and non-compliance with the said order by not allowing him to join the post of Assistant Superintendent RMS, the respondent filed an application for initiating proceedings for contempt against the opposite parties. On that application, a rule nisi for contempt was issued by the learned single judge who had issued the earlier rule and passed the interim order. After hearing the parties, the learned judge made the rule absolute against the two appellants and ordered them to pay a lump sum of 5,000 rupees to the respondent, with a direction that the said amount would be adjusted from the sums payable to him. Hence this appeal. Para 4. In the application praying for initiating a proceeding for contempt against the appellants and others, the respondent asserted that on the day when the order was passed by this court, being 17 September 75, he was functioning as an assistant superintendent and was being paid as such. Consequently, he was entitled to continue in the said post and receive all emoluments related thereto pursuant to the order of status quo passed by the court. The appellants contested the above claim of the respondent and submitted that consequent upon the issuance of the order of reversion dated 10th March 75, the respondent ceased to function as assistant superintendent RMS, and that was necessary, and that necessarily meant that on the day the interim order of this court was passed, he was functioning as an inspector. There was no violation of the order, the appellants urged. Now, para 5 deals with the single judge. Para 7, Lordship.
Just wait, I'll take a small break and come back.
I'm deeply obliged. Grateful.
So we'll resume after some time.
We'll wait for Lordship.
So we can rise.
So, Lordship, I was reading that Calcutta High Court judgment.
Yes.
So, I was on para 7. If Lordship, Ladyship may please come to para 7. In this jurisdiction, we are not called upon to decide whether the order of reversion is legal and valid, and our attention has to be confined to the question whether the two appellants have willfully disobeyed and violated the interim order of the court directing the parties to maintain status quo. Admittedly, the order dated 10th March 75 passed by the appellant number 2 was communicated to the respondent on 17th March 75 when he was in leave by the appellant number 1 through his memorandum dated so and so. It is also not in dispute that in the representation dated for April 4th made to the Postmaster General, West Bengal Circle, the respondent admitted his reversion. But he submitted that it was abrupt and unexpected, and as his juniors had been allowed to work as assistant superintendent, and prayed for revocation of the order of reversion. While showing cause against the rule for contempt, the appellants maintained that in the context of the above facts, they took the view that on September 17, the respondent was holding the post of inspector, and therefore the order for maintenance of status quo meant that the status as inspector should not be disturbed. In the ultimate analysis, the view so taken by the appellants may not be found to be legally sustainable, but then if such a view was taken bona fide, it cannot be said that it amounted to willful disobedience of an order of the court. So even if the order is, even if the decision taken may not be legally correct in an ultimate view, but if it was done bona fide, it cannot amount to willful disobedience. In our considered view, para 9, a proceeding for civil contempt cannot be predicated upon the disobedience of an order or direction which provides scope for different and reasonable and rational interpretations. Similarly, if the direction contained in an order is subject to or dependent upon determination of some other facts, the violation of such directions cannot give rise to a proceeding for civil contempt. Respectfully, Lordship, this judgment summarizes our position to the case at hand, especially para 9. That, Lordship, particularly when a direction contained in an order is subject or dependent to a certain determination of certain facts, they cannot be contempt. And respectfully, Lordship, we have complied with Lordship's direction in the judgment. And we would say that it is done in a bona fide manner. There is no intent of any evil motive, any desire to be in not follow Lordship's directions. There is no intent or willful disobedience of the same. We have implemented it because the order had certain dependencies, or it was qualified with certain additional things to be considered. On considering the same, we passed the said order. Then, Lordship, my next judgment, Lordship, we have done everything, Lordship, only as per rules. And the rules provided us clearly, there's complete clarity in the chart we've given in our affidavit in opposition. The petitioner never completed her total 4 years of probation. And more importantly, the rules are not under challenge. So they cannot say that our reliance on something that is not on challenge, the rules, is not correct. I am now reading, Lordship, the next judgment, which is 2019. Ladyship may also mark 16 SCC 360. This, Lordship, Badri Vishal Pandey versus Rajesh Mittal, Justice Khanvilkar and Justice Gupta, Hemant Gupta, essentially holds that the court, that a person cannot seek reinstatement on the basis of a contempt proceeding. So reinstatement through a contempt proceedings is not possible. Para 1, Lordship, Ladyship. The present contempt petitions arise out of an order passed by this court in 15, where the order read, it is submitted by the learned counsel for the petitioner that it has been decided to take the respondent workmen on daily wage basis as per the office order dated so and so. So, and the list contained therein. Needless to say, the names of the respondent workmen are included in the list contained in the office order dated so and so, which has been filed before this court. The learned counsel for the respondent submitted that as the names of the respondent workmen are included in the list as per the aforesaid office order, they have no grievance. Recording such concession, the special leave petition stand disposed of. There is no order to cause. 2. Earlier contempt petitions filed before this court alleging non-compliance with the said order were disposed of in view of the fact that the name of the respondent workman had already been included in the seniority list. Para 7. And if Lordship, Ladyship may be pleased to come just above placetum D in para 7, which starts with the words, all such special leave petitions. After quoting the judgment, Ramchandra versus Labour Court, all such special leave petitions were decided by the common order dated 7/9/2015 on the basis of the office order dated so and so, wherein it was resolved that in future, as and when any vacancy arises on daily wages muster roll, preference will be given to terminated retrenched employees of the department. A list of 1,003 retrenched workmen were attached to such communication. The extract of the order is below, which basically talks, Lordship, about preference. Para 9. Para 8, Lordship may just see just the first sentence. Contempt petition so and so has been preferred by 62 petitioners, but only the first petitioner was a party before this court. Para 9. In the written submissions filed by the counsel for the petitioners, it is averred that an impression was given by the Jal Board, Nigam, that it shall comply with the directions of reinstatement passed by the High Court. Para 10. Second sentence, it is again averred that the impression was given that the Jal Nigam shall do the needful to comply with the order dated so and so. Para 11. The learned counsel for the petitioner relies upon communication dated so and so to contend that 550 vacant Group D posts are available, and therefore, this is the contention which is important. Petitioners can be reinstated and regularized against the vacant posts thus available. Therefore, it is contended that the erstwhile daily wagers engaged on muster rolls are required to be reinstated. Now, what is the holding in para 25? Which is at page 369, internal.
Please read paragraph 19 also.
Sure. Anything else before that, before 25, Arnab, besides 19?
That's all.
Para 19, if I may, for Lordship and Ladyship, just read that. The order dated so and so has been passed on the basis of concession given on behalf of the workmen in light of the circular dated so and so. There was no order of this court to re-engage the workmen who were parties in the special leave petitions. Therefore, in the absence of any specific or categorical direction of reinstatement, the petitioners cannot claim any right for reinstatement on the basis of the orders passed by this court on 7/9/15. Still further, 61 petitioners were not party in the group of the special leave petitions, which were decided on so and so. So my learned friend, I'm assuming, subject to correction, is seeking to say that a large number of the people were not petitioners before the court. Of course, everyone here is a petitioner who is before the court in our case.
There was no direction to reinstate.
Para 25.
Yes.
Yes, please proceed.
Yes. Still further, there is no direction in the order passed by this court to reinstate the petitioners or to place them in minimum or regular pay scale. The contempt jurisdiction cannot be invoked on the basis of impressions when the order of the court does not contain any direction for reinstatement or for grant of regular pay scale. The contempt would be made out when there is a willful disobedience to the orders of this court. Since the order of this court is not for reinstatement, the petitioners under the garb of contempt cannot seek reinstatement when nothing was granted by the court. Pause. Now, this is a nuanced argument that I'm making, Lordship. The argument is there is no specific direction for unconditional reinstatement in Lordship's order, judgment. Para 140 does not say reinstate the petitioner and full stop. No blanket reinstatement. Para 140, on the contrary, makes the reinstatement subject to directions therein below. Those directions have to be read in context of the rules which are not in challenge. Rule 21, applicable to the petitioner. The probation period is 2 + 2, maximum 4 years. The petitioner never completed 4 years. It's a matter of record. Hence, the reinstatement becomes conditional to completion of probation, which is the direction in Roman 7. Additionally, Lordship, in the judgment, there is a specific direction that the state can issue a fresh order of discharge if they are probationers after considering the said rules. And the state has done so. Since they were probationers, we complied with the directions in para 141 Roman 7. Respectfully, how can they allege contempt for us as a state of complying with the direction in the judgment? Number 2, there is no intention to not follow Lordship's directions. There is no willful disobedience, there is no intention, there is no mens rea, there is no evil motive. Even though, respectfully, I would say that there is no carelessness also or heedlessness also. Nevertheless, if this honorable court felt that there was an error in terms of how we interpreted it, that also cannot be invoked in terms of under the contempt jurisdiction. Third, Lordship, to conclude, the directions are not only qualified, they may be considered to be requiring an interpretation. If there is interpretation or two views are possible, then that benefit of that two views has to go to us. We can't be held guilty of contempt. Now, Lordship, two additional points beyond the law on contempt jurisdiction for Lordship and Ladyship to consider.
Yes.
The first is, Lordship, the very fact that the private parties have filed a review and that review stands admitted. The state has also filed a review, but only to the effect or extent of the service rules in terms of para 67 and 68 would indicate towards interpretation required in determining the import of the directions. Of course, Lordship, I have already pointed out, and Lordship, Ladyship are aware that the SLP is pending before the Honorable Supreme Court. Of course, and Lordship had also passed an order to that effect, saying that the petitioner herein is not a party in that SLP, but I'm just simply pointing out that that does exist. Now that brings me to the final point. The final point is, my learned friend may and is entitled to argue on the non-service of the discharge order onto the petitioner. I would respectfully say that cannot be invoked in the contempt jurisdiction. That is a fresh cause of action, and my learned friend and his client have every right to consider their legal options on a fresh cause of action. I am deeply obliged, Lordship, Ladyship, for forming the special bench, and Lordship, Ladyship giving me such a patient hearing. That is all I have to say, and I would just pray for Lordship and Ladyship's indulgence and judicial magnanimity to discharge the state and its officials from any allegation of contempt. Without prejudice to that, our unconditional apology is on record because we are duty-bound and obligated to uphold the majesty of the courts and also to follow in letter and spirit the directions and judgments passed by the Honorable Court. Deeply obliged.
May please.
Yes.
My learned friend, my lord, has argued, my lord, on the entire gamut of the contempt jurisdiction, my lord. He has placed the law on contempt. And his submission is this, my lord, that rightly or wrongly, if an order is passed, it may be an error of judgment on the part of the department in complying with the order or in compliance with the order which the lordships intended. But that cannot be contempt. That's my friend's argument, my lord. You place the judgments also. But, my lord, I was looking for which order is he talking of, my lord? The order which he placed before your lordships on 18 February 2026 is by way of a defense in a contempt jurisdiction, telling your lordships that we have complied with the order. Now, his further argument, my lord, in his closing is, whether it is right, whether it is wrong, contempt court cannot go into it. Why not, my lord? Your lordships will see whether the order has been complied with. And the orders which my learned friend placed on record, my lord, of 11th July 2025 and 21st July 2025, that corrigendum, my lord, keeping it in abeyance for 30 days in compliance with your lordship's order, on his own showing in the affidavit in reply, opposition in the contempt has not been served, my lord. It has not been published. So there is no order in the eyes of law. One could have imagined, my lord, that there is a valid order. Your lordships could then have taken a view that, see, they have complied with the order. Like that seniority list, my lord, in J.S. Parihar's case, that 1996 judgment. Seniority list was published. Whether, my lord, it was to the satisfaction of the petitioner or not, Supreme Court said, no, we will not go into it. This is not the gamut of the contempt jurisdiction. We will not go into whether that order has been rightly passed or wrongly passed. You approach an appropriate proceeding. Now, let's their affidavit in opposition, my lord, which I say is a show cause to the contempt, my lord, because the lordship issued a notice, my lord, to the contemners. And that show cause itself admits that this order was never sent to the petitioner. Their justification is, why was it not sent? So they admit, my lord, that this order was never sent to the petitioner. This order was never served on the petitioner. And this order was not even published in the official gazette. And their specious defense is, my lord, the plea is, we did not have the updated email ID of the petitioner. My lord, I have placed, my lord, records that I am in correspondence with my department. I reside in Gauhati. My email ID is with my department. The 2019 discharge order was sent on my email ID, which I still use. And if they didn't have, my lord, the updated email ID, what stopped them from serving me through the police station, my lord? There are other modes of service. No, my lord. On their own pleadings, my lord, in the so cause, there is no non-compliance of the judgment of this court. That order which they have placed, my lord, on their own admission is no order in the eyes of law. It's an order, my lord. At best, my lord, if I am ready to give them the benefit of doubt, exists on the file, my lord. And my respectful submission is, my lord, it doesn't even exist on the file. And I will place that, my lord. Will your lordships have, my lord, the order which my friend's client has filed, my lord, Akashji, with the affidavit in opposition, my lord, at page 246. And this is serious, my lord. We are dealing with a state, functionaries of the state, senior officers.
Yes,
The lordships have page 246.
yes.
My lady has page 246, my.
Yes, yes.
Yeah.
Yes, sir.
Just have, my lord, who is it marked to, my lord? One, Accountant General Assam. We issued we asked in RTI, my lord, do you have a copy of this order? They say we do not have. Our records do not have that. That I have filed in reply to the IA. Then your lordships will mark, my lord, something very glaring. Number 4, look, who is it addressed to, my lord? The chairman, Assam State Electricity Board, Gauhati. My lord, Assam State Electricity Board was unbundled in 2004, December. There is no Assam State Electricity Board, my lord. So this is what happens, my lord. Somewhere you leave a clue. We wrote, my lord, to that ADPCL, APDCL, my lord. APDCL says that it doesn't concern us. We don't have a copy of it. And it's a matter of record, my lord, that Assam State Electricity Board was unbundled, my lord, in December of 2004. My lord, I've given that date, my lord, in my affidavit in opposition. It was unbundled on 10th December 2004. And my lord, Assam Electricity Grid Corporation, this is after the Electricity Act of 2003, my lord. So there is no Assam State Electricity Board to whom, my lord, the order is addressed. Now, my lord, also have the Chief Electoral Officer, your lordships have that, my lord.
Yes.
Serial number 6.
Mm.
In response to the RTI, they said we have no record. Similarly, my lord, the government press, my lord, serial number 16. We do not have this notification. And what is important is serial number 21. My name is not even mentioned. It's kept blank. And I shudder to say, my lord, think, my lord, if this is, my lord, the official record which the department maintains of having discharged an officer in purported compliance of your lordship's judgment. Now, my lord, that corrigendum also, my lord, at page 248. Again, my lord, marked to Assam State Electricity Board, Chairman AACB, my lord. And serial number 21 again, my lord. is blank. So this is what was placed before your lordship on 18 February 2026. When your lordship, my lord, passed a detailed order, observing, my lord, prima facie, that it is in contempt. Your lordship said, my lord, purge yourself of the contempt, permit her to join within 30 days.
Don't see any. Just in a lighter note, we don't see any
Reaction.
James Bond movies. Once somebody is erased, that is how they do. Dot, dot.
No, this is what you don't have to hide the truth, my lords. But if we try to create, my lord, this is what happened. ASCB unbundled in 2004, a non-existent.
I'm so sorry. Just only for the record, we will happily produce Lordship the records of this file, and so that you know.
That should have come, my lord. Your lordships have already.
I will, and please, Lordship, may record it. We'd like to place it for Lordship and
No, it's
Ladyship's
not, my lord.
consideration.
We have not placed it
So that, no,
yet.
Lordship, no, we'll place it. Of course, we will. And
No,
Lordship
please
may
have-
record it. It's my one. Just a moment. I'm on VC, so I don't have the advantage of being able to speak, with a break. It breaks the audio. Thank you. I was just saying, Lordship, Ladyship, may please record my submission. We'll produce the complete record, the file, to establish that there is no cover-up.
Let Mr.
at
Chaudhary
all.
complete.
Of course, Lordship. Just only on that point, because I want my bona fide of the file to be there. I'm sorry, I apologize for again interrupting. The idea was not that.
It's fine. No, my lord, this is a document from their file. It is a document they have produced trying to show compliance of the judgment of 20th June 2025. Now, let's please have Annexure A3 at page 250. And this document, my lord, completely nullifies, my lord, the order which they have placed of discharge of 11 July. Please have, my lord, it's their own document, my lord. After your lordship's order of 18 February, they issue a notification on 26/2/2026. Because your lordships have issued them the notice to show cause on the contempt petition. So now, my lord, look at what they do, my lord, immediately after 18 February. This is a notification of 26/2/26. The lordships will see, my lord. Lordships will skip the first paragraph. First paragraph refers to your lordship's the judgment of 28th June. Please, my lord, also have in the first paragraph, they have correctly, my lord, interpreted the order. The Honorable Division Bench of the Gauhati High Court, by the judgment dated 20th June 2025, passed in a batch of 47 writ appeals, including writ appeal number 14 of 22, that my client had partly allowed the said appeals and issued specific directions on the paragraph 140 thereof. Amongst other directions, the competent authority in the respective departments are directed to reinstate those appellants, please mark, who had completed their initial period of probation of 2 years within a period of 50 days from the date of the said judgment and order. That's the reading of the judgment. That those who have completed the initial period of 2 years has been directed to be reinstated by your lordship's judgment of 20th June. Now, please see, my lord, in compliance with the said judgment and order of 20th June 2025, the Transport Department passed a fresh discharge order by notification dated 11/7/25, followed by a corrigendum dated 21/7/25. But please mark the next sentence. However, it has been brought to the notice of the government that the said discharge order, notification, and corrigendum were not served upon Srimati Suranjika Hajarika, the concerned appellant. So what? Where does the order stand now, my lord? If you don't serve an order, my lord, that order is non-existent, not binding. And that order, my lord, cannot be a defense in a contempt proceeding. Unless, my lord, my learned friend first satisfied that this is an order passed, the order is a valid order. And my friend can do this and no more, my lord. He has done his best. Now, my lord, the next sentence. As the updated email ID address of the petitioner was not available with the Transport Department, alternate steps, including forwarding the order for the publication in the official gazette, were reportedly undertaken. However, Please mark, my lord, the Gazette publication could not be completed. Reportedly, my lord, once again, due to administrative oversight at the level of the government. So everything is happening, my lord, in the department. First, my lord, the order is not addressed to the petition. Then, admittedly, we have not served the petitioner. Why? We don't have the updated email ID. We tried alternate modes of publication. That also could not be done. Why, my lord? Due to an administrative oversight at the level of the government press. After this notification, my lord, what remains of this 11th July order, which my friend said I have complied? Now read further, my lord. Srimati Suranjita Hazarika filed the contempt bearing number so and so before the Honorable High Court, alleging disobedience of the judgment dated 28 June. The matter was heard by the Honorable Division Bench on 18/2, whereupon the court issued the following interim directions. Respondent shall permit the petitioner to join her service within 30 days from the date of the order dated so and so, in order to purge the alleged contempt. So they are in knowledge of the order. Your lordships have directed them to purge the contempt, allow joining. The respondent shall file their respective orders. It has been observed that this is a matter of serious administrative lapse, and the possibility of a criminal conspiracy or connivance of government employees cannot be ruled out. In view of the foregoing, and in order to inquire into the administrative lapses that has resulted in the failure to serve, one second, madam, failure to serve the discharge order / notification of 11/7/25, along with the corrigendum of 21/7/25 upon the petitioner Srimati Suranjita Hazarika, the government of Assam is pleased to constitute an administrative inquiry as follows. So now they appoint an inquiry. They don't serve, they don't publish, and now they appoint an inquiry. In all this, my lords, obviously because the lordships have already issued notice on 18 February, 29 January. Inquiry Officer Ajay Tiwari, IAS, Additional Secretary to Government of Assam, Home and Political. Scope of inquiry is similar. To examine in detail and identify all the administrative steps taken or required to be taken by the Transport Department, other concerned officers for communication service of the discharge order that notification of 11/7 and the corrigendum upon so and so. To identify the specific lapse or omission that resulted in non-publication, non-service of the said order upon the petitioner, including but not limited to the failure at the level of the government press in completing the Gazette notification, to identify the officers, employees responsible for such lapses, and to fix responsibility upon them, to examine whether the lapse was due to deliberate and intentional, and on explicit connivance of any employee with the accused, to make such inquiries. And please give a time frame, madam. The inquiry officer. The inquiry officer shall complete the inquiry and submit a detailed report along with the findings and recommendations within a period of 2 weeks from the date of issue of this notification for placing before the competent authority. As I address your lordship, 2 weeks elapsed long back. It's more than 16 weeks. And this self-serving inquiry, the outcome of this inquiry is not placed before your lordships. But what is apparent from this odd notification is, my lord, that the order of 11/7/2025 and the corrigendum of 21/7/2025 is non-existent insofar as the petitioner is concerned. It is void, it is not binding, and it is not an order at all for the respondent contemners to place it as a defense in contempt jurisdiction. I had placed on 18th, Bachitkar Singh's case, if you lordships recall, the Constitution Bench judgment, which says, an order in file is no order. It is essential attribute of a valid order that the order must be served on the intended recipient. If I may just place Bachitkar Singh once again,
Bachitkar Singh referred in the order.
Yes, in the order, your lordships have referred, which says, your lordships, I'll just read that part, It says, paragraph 10 of that, thus it is the essence that the order has to be communicated to the person.
Just a moment, my sister will have this addition.
Yes, we have already given my friend has handed over. Mr. Marto,
It's okay.
I have requested my Marto Kato advocate to hand over. Your ladyship has Bachitkar Singh. Bachitwar Singh,
I think I'll get it.
Marto,
In a minute, I'll get it. What? Actually,
Yes, sir.
please hand over.
Lordship, just before I handed over the compiled one.
yes, yes.
Yes.
Get it
This is
there.
Yes.
Bachitwar Singh, that's loose one, AI 63 Supreme Court.
Sister, it is AIR 1963, Supreme Court 395.
Actually, I have. 1963. I have. I have.
Yes.
Very grateful, Marto. Just above paragraph 11, Malak. Before that part of paragraph 10, Malak. Before the quotation, which of them, the sentence beginning, Malak, third line from the top. Which of them can be regarded, my lord, there?
Paragraph 10.
Yes, Malak. Second page of paragraph 10, Malak. From the top third line, which of them, the sentence beginning, Malak, which of
Yes,
them
yes.
can be regarded? There is a quotation in paragraph 10, Malak, before the quotation,
Yes.
Yes.
third line from the top. Which of them can be regarded as the order of the state government? Therefore, to make the opinion amount to a decision of the government, it must be communicated to the person concerned. Then, my lord, it quotes from State of Punjab versus Sodhi Sukhdev Singh. And please read, my lord, after the quotation, thus, that subparagraph. Thus, it is of the essence that the order has to be communicated to the person who would be affected by that order, because the state and that person can be bound by that order. So before, my lord, the person is bound by that order, my lord, this order will have to be communicated to the person to whom it is affected. For until the order is communicated to the person affected by it, it will be open. My lord, this is the question of Council of Ministers to consider the matter over and over again till communication. The order cannot be regarded as anything more than a provisional in character. Similarly, on the same light is 1998 7 SCC 569. Union of India versus Dinanath Santaram Karika. So, my lord, an essential attribute of a valid order requires, my lord, that the order should be served to the person to whom, my lord, the order is affected, impacted, to the person, my lord, to whom the order is addressed. Till then, my lord, it is a draft order on the file.
This is about the 1998, man.
Yes.
So-
Thank you, Marto. Well, please have, my lord, the head note B.
Yes.
Head note B, my lord, at page 571. Termination of service, communication of order. Order passed in file but not communicated to terminated employee. Termination held does not become effective. Where the services are terminated, the status of a delinquent as a government servant comes to an end, and nothing further remains to be done in the matter. But if the order is passed and merely kept in the file, it would not be treated to be an order terminating services, nor shall the order be deemed to have been communicated. The relevant part is paragraph 9. Yeah, my lord, the order was not served, charge sheet was also not served. So the Supreme Court said, my lord, that the entire proceedings are vitiated. Now, my My learned friend, my lord, placed paragraph 141(1). And my friend's contention is, my lord, this is, my lord, in the prejudice. Without prejudice to my contention that contempt is made out on the stand taken by the contemners in their affidavit in opposition, that this order was never served, nor communicated, nor published. That's an admitted position. So this is no order in the eyes of law and cannot, my lords, be even construed as compliance of the judgment of 28 June 2025. Whichever clause my learned friend puts me in, my lord, whether I am in 141(1), my friend says I'm not, because probation is 4 years, my friend has said. 2 years extendable by periods of 2 years. And my friend says I fall in 141(7). That is, you have not completed the process. But 141(7), your lordship says, if there are any appellants who have not completed the period of probation, that is, my lord, below 2 years. But the host that, my lord, we go by my friend's interpretation that I fall in 141(7). There is no order. So, my lord, the contempt, my lord, in my respectful submission is made out on the stand of the contemner. There is no compliance of the judgment of your lordship for 28 June 2025. Even if I am ready, my lords, to bow to my learned friend's interpretation that I fall in 141(7), your lordship's directed pass orders within 50 days. 50-day period expired in August, 8th August of 2025. Day after tomorrow, my lord, we will conclude 1 year after your lordship's judgment, my lord. Judgment has not been implemented so far as the petition is concerned. That's, my lord, my first step. So, my lords, all defenses which my friend has raised, that the validity of the order, you will test it elsewhere, my lord, is unavailable in view of the fact that there is no order of the charge. This is, my lords, without prejudice to my contention that the order of discharge which my learned friend has placed is a suspicious document. It is addressed to, my lord, the Assam State Electricity Board, etc. I have pointed out. And my RTI replies where they have stated, my lord, there is no such notification in our record. So, my lord, the second part is even, my lord, serious.
That is why the inquiry. It is why the inquiry.
That is what it is.
Conspiracy that everybody is denying receipt of that.
Yes. Everything is happening in the department, my lord. The gentleman who signed the order, assuming provided he has signed it, he doesn't even check that the order is a draft order. It is not even addressed to the officer to whom it is intended. The name is also not written, it is kept blank. The 2 weeks inquiry period expired, my lord. Way back, we have 16 weeks now. What has transpired in the so-called purported in-house inquiry, my lord, we do not know. The lordships have not even been informed about that inquiry. So my respectful submission, my lord, the inquiry, my lord, was a smoke screen which they wanted to create, my lord, to raise a defense before your lordships in the contempt. Now, my lord, secondly and more importantly, my lord, please have your lordship's order of 18 February 2026. My friend, my lord, placed the initial part, my lord.
You have to summarize because then we'll have to summarize against some other day.
We'll conclude, ma'am. I'll take another 10 minutes.
Because at Itanagar, there's a lot of pressure.
I know, my lord. I'll close in 10 minutes.
18-2.
Yes.
Yes.
18(2), my lord. Please come, my lord, straight away to paragraph 13. Paragraph 15, my lord. Paragraph 15, my lord.
Yes.
From the copy of the notification dated 11/7, which is produced before this court, it discloses that the previous discharge order against the petitioner was passed on 21/1/19. There is no material available on record before this court as to how the notification dated 11/7/25 and the corrigendum was served on the present petitioner. Now that's answered, my lord, in the affidavit in opposition that we have never served. This observation is made because the learned senior counsel for the petitioner emphatically stated that as on date as per his instructions, the said notification has not been served on the present petitioner. He submits that the present petitioner is present in court hall and he has been instructed to say so. Then your lordships had that para 16, my lord. Be that as it may, though it is seen that the discharge orders of the petitioners had been set aside by the impugned notification, the discharge orders have been substituted in terms of the directions of this court with effect from 21/1/19. But by the effect of the corrigendum, the said notification is to come into effect from 21/7/25. Thus, it prima facie appears that the discharge order of 21/1/19, which has been set aside by this court, is sought to be substituted by the notification dated 11/7/25. In the absence of the affidavit by the respondent, it is not clear as to whether in compliance with the provisions of Rule 21, any order was passed by the competent authority for extending the period of probation in respect of the petitioner. This observation is incidental and not binding. Now, please have, my lord, now paragraph 18. Therefore, this court, in order to ensure that there is no continuance of disobedience of the directions of this court, so as to uphold the majesty of this court, is inclined to hold that the respondents are required to first show that they have purged of their contempt. This is a lordship's finding, prima facie though. And therefore, as the notification of 11/7/25 produced before the court is relatable to the discharge orders of 21/1/19 that has already been set aside by the common order, judgment and order, the court is inclined to pass an interim order in terms of prayer 3 of the contempt petition, directing the respondent contemners to permit the petitioner to join her service without prejudice to the defenses which may be available to the respondents in this contempt petition, which shall be done within the period of 30 days of the order. Now, my lords, in their response before this court, my lords, the deponent, Mr. Akashdeep, has stated before your lordships that there is no question of purging contempt because we have issued the order of 11 July. So your lordships, my lords, on 18 February itself stated, taking into consideration the orders passed, the stand which was prima facie disclosed at the time of argument and directed that they should purge the contempt. To uphold the majesty of the court, they must first purge themselves, allow me to join. That has not been done till date, my lords. It's been a period of 4 months, my lords. And my respectful submission, today we are completing 4 months, 18th June, 18th February. My respectful submission is, my lords, non-compliance of the order of 18th February has further, my lords, aggravated the contempt. The contemners, my lords, are in brazen breach of the orders. This breach, my lords, in my respectful submission, slides on the majesty of this honorable court. And I have highlighted, my lord, the pleadings in my reply, which I have filed to the IA, where they have stated, my lords, that there is no question of purging because we are not in contempt. A stand, my lords, taken by a contemptor, my lords, telling the court that the order direction of the court, my lords, cannot be complied. There is no question of complying. There is no question of purging, since, my lords, we have already complied with the order of the court, my lords. That your lordships will find. Just mark that part, my lords. Paragraph 5, my lords, at page 6 of the IA. Consequently, when there is no disobedience of the directions, then the question of purging contempt by allowing the petitioner to join services does not arise. So this is a stand, my lords, which I respectfully submit, my lords. Can't be countenanced, my lords, from a contemptor who is showing cause before your lordships. And then, my lords, he further goes on to say, unless the discharge order is set aside or quashed by the honorable courts, the petitioner cannot be allowed to join services as an interim measure. This, my lords, is a direct affront, my lords, to the majesty of your lordship's court, my lords. And to conclude, my lords, there is a compilation of judgments I have handed over, my lords, and my friend. Well, there the relevant paragraphs are there. I will not read it, my lords. The lordships can just, unless the lordships want me to place the relevant part, where the court has said, my lords, that the court must implement. Can I take your lordships through it quickly, my lords?
Yes.
Or your lordships want to reconvene after lunch?
No, then we'll have to break up.
I'll just quickly take your lordship through it. I'll not repeat, my lords. First, my lords, that Tirupati Rao, my lords. First, my lords, Kisti Goswami, lordship paragraph 11. I had placed it, my lords, on the day when the lordship issued notice. That High Court can,
serial number 3, madam. Serial number 3.
Yes.
that the High Court can direct, my lords.
Yes.
That the High Court can direct, my lords, to implement the order of the court. So, my lords, the judgment of Justice Khanvilkar, if my learned friend relied, there was no positive direction for reinstatement of those workmen. That's why the court says there is no direction. So, where is the question of contempt? Now, my lords, please come straight to serial number 3, Tirupati Rao. And just read 2-3 paragraphs of this quickly, my lords, and it's Sitaram. We wish paragraph 63, my lords, at running page 99. My lords,
Just stop. Page 99.
yes, running page 99, my lords, of my compilation.
Yes.
Paragraph 63. We wish to add that this by way of a clarification, that this is Justice Dipankar Datta's judgment, my lords, that concomitantly there lies a bounden duty on the contemner to comply with the court's order without any delay in case where legal recourse has not been taken to set aside, review, vacate the order which is alleged to have been breached. Same here, my lords. A public official against whom an allegation of contempt is leveled, please mark, my lords, upon being noticed either by issuance of a rule of contempt or by court notice, must work out his remedy in accordance with law if he wishes not to comply with the court's direction. He must not wait for compliance to be secured only upon all the phase steps to be taken by the High Court in terms of paragraph 44 of the Association of Retired Supreme Court and High Court Judges forming part of the SOP are complete. A public official who is arraigned as a contemner is as much bound by an unchallenged order of a High Court as a private party and cannot consider himself not bound by law by virtue of the office he holds. Being under a duty to comply with the final and binding order of the High Court, the contemner ought not to drag his feet in doing the same until the coercive measures of summoning the contemner to be physically present is resorted to by the court. Similarly, I am skipping the remaining part, Milas. Please come, Milas, to paragraph 71 and 77. In exercising his jurisdiction, my lord has, page 103, running page.
Yes.
In exercising his jurisdiction to punish for contempt, the courts in India do not keep in mind the benefit that would accrue to the petitioner informer if he is a party to the parade proceedings out of which the contempt arises upon the implementation of the order alleged to have been willfully disobedient. But more than anything else, the endeavor is to uphold the majesty and dignity and prestige of the court. Indubitably, the jurisdiction to punish for contempt is exercised when the alleged contemner by his actions shows extreme lack of solicitude in complying with an order of the court, which has attained finality and is binding on him. So long as a final order passed by the court is not set aside, it continues, or an interim order is vacated at a subsequent stage, it continues to bind the parties to the proceedings, and it would, please mark, my lord, amount to subversion of the rule of law if any party in breach were encouraged to continue such breach. An order of a court has to be complied with, and it would not amount to a valid defense. Then in the contemner's own understanding, or because of legal opinion tendered to him, the order did not warrant compliance, being erroneous. Then, para 72, minutes. Where, I've stated, that impeding the course of justice, from paragraph 72 onwards,
Yes, 72.
Yes, 73, that Lord Danning's Atkinson versus Atkinson. Then Anil Panjwani. And at page 105, court says, that if you don't purge, you will not be heard. Though it's a very serious step which the court takes, but the court says that it is essential, to maintain the administration of justice.
77.
Yes. Paragraph 76 and then 77. Now, the next judgment I had placed in the opening, my lords, the latest judgment of the Supreme Court in Israr Ahmed Khan, my lords. Running page 117. Justice Amanullah's judgment, my lords, where he says, my lords, that state is, my lords, dragging their feet in judgments. They are not implementing. So the court, my lords, has said it's a serious matter. And the judgment has been circulated to all the high courts, my lords, to take a stern view of the state not complying with judgments, my lords. This is one such case, my lords. And my lords, the last judgment I would rely upon, my lords, is Sitaram Enterprises, 2024 SCC online, SC 2493, my lords. Just one passage, my lords. Please see, my lords, the quotation at the top, order, first page.
Yes.
Your Lordship, disregarding, please see the quotation, my lord. Disregarding a court's order may seem bold, but the shadows of its consequences are long and cold. And then, my lord, it says, my lord, contempt of court is a serious legal infraction that strikes me. Your Lordship will just mark paragraph 1 to 3, my lord, where it says, my lord, that the court must, my lord, in the case where the defiance is established, my lord, take steps under the Contempt of Courts Act. Now, my lord, one is, the last judgment is Rupa and Company, my lord, 2025 SCC online, Justice Gauhati's judgment. My friend Mr. Kohli appeared in that case, my lord. Rupa and Company. What is Rupa and Company?
That is the problem. That when two friends argue, then the entire body is on court.
Lordship, the famous words of Justice Midda on retirement. In any case, both sides know the truth. It is the judge on trial.
It is the judge who is on trial. But here, my lord, the truth is apparent, my lord, on the record. Just have this, my lord. This was a case, my lord, where court held paragraph 11, my lord, that it is an aggravated contempt. The court said, my lord, under the constitutional scheme, writ issued by the High Court, which has not been interfered, has to be followed in letter and spirit by all authorities who are bound by such a writ. Para 12, my lord, the majesty of law requires that due obedience has to be given to the command of the High Court. And, my lord, under the contempt of court rules, my lord, your lordships have already issued show cause, my lord, to the contender. Then if your lordships just have the rule, my lord. Civil exchange, this is civil contempt, my lord, rule 9. And rule 11. In the case of civil contempt, the High Court may determine the matter of charge on affidavits filed on such further evidence as may be taken itself or recorded by a subordinate court in pursuance of a direction and pass such order as the justice of the case requires, having regard to the provisions of the section 12 and 13 of the Act. And in my respectful submission, my lord, section 13 of the Act says, my lord, if it tends to interfere with the administration of justice, my lord, or substantially interferes, my lord, then the contempt is punishable.
Lordship, if my learned friend has finished, I just have a sentence or two to add.
Section 13, my lord. For punishment, my lord, your lordships will not
Contempt of
unless
Court Act.
it interferes or tends to interfere. And this is the case, my lord. In my respectful submission, the non-compliance of the order of 18/2/2026, my lord, has aggravated the contempt. It interferes in the administration of justice of this honorable court. And it's a fit case, my lord, where the contemptor, my lord, must be punished for contempt. What punishment your lordships will give, my lord, that your lordships will have to decide. And last, my lord, 26th March 2026 order, your lordships, my lord, In fact, I just placed the notification, your lordship, my lords, passed a detailed order granting protection, my lords, to the petitioner, saying that since you have now brought out a criminal conspiracy, under that notification of, my lords, that March notification after your lordship's order, your lordship passed a detailed order. In paragraph 10, your lordship said no coercive threat, and she shall not be arrested, my lord. I'm praying, my lord, that order must be made absolute when your lordship passed. I'm very grateful.
If lordship would permit me, there's 3-4 sentences. One is, lordship, my learned friend has relied on Tirupati Rao judgment. Lordship, we also rely on it. Just lordship may mark the paragraph numbers. Para 38, 39, 47, 48, actually 47 to 52. Para 38, 39, 47 to 52. Because in that judgment, our point is that we have taken the steps in terms of vacation of stay, review. We have not argued vacation of stay because lordship is now looking at the entire.
You are referring to which judgment?
Tirupati.
Tirupati Rao, my lord, that my compilation,
We also rely on it.
which I read out, my lord, Justice Dipankar Datta, serial number 3, 2024-20 SCC. My friend is relying upon a few paragraphs.
Yes, lordship. Para 38, 39, 47 to 52. That judgment's ratio is, if any steps have been taken, then of course, contempt won't lie. But I'm leaving it now for lordship. I won't read those paras. Second point, lordship. Since my learned friend had raised, perhaps even berated the state and its officials in terms of the file and how the order speaks for itself, the file should also speak for itself. I would, lordship, request lordship to record it that we place the file and the specific note sheet for your consideration. And lordship may please see that. Because I say that on instructions, the inquiries that are proceeding also show that the procedure followed within the department at the senior level was very clear. It was for compliance of lordship's order. So that lordship may please call for that file. I would request lordship, because you are dealing in the contempt jurisdiction. And that note sheet, even if it's only the note sheet, we can place that, but do record it, lordship. And I would urge lordship, ladyship to definitely have a look at that. And of course, lordship, the final point, and no more than this, lordship, is the non-service cannot be the subject matter of a contempt jurisdiction. The decision can be. And the decision will be clear from the file. The non-service cannot be argued as invoking the contempt jurisdiction. That's a separate cause of action.
You see, Mr. Kohli, calling for the records subject to what we deliberate after we rise, me and my sister. The view is very clear that in contempt jurisdiction, we are not expanding the jurisdiction to call for the records. Because then we would be looking into something or to which the other side would have no privy. So that is one point.
Fair.
Second is that you have also shown from the judgment that the scope of the contempt is limited to whether there is a contempt or not to further go and then try to find out an evidence. So therefore, for that part, me and my sister will speak.
I bow actually, lordship. Lordship has said the correct thing, and actually that is the law. Because my learned friend is arguing on the form and the non-service, I am constrained to place that for your consideration. That's the only thing.
For that, we both will deliberate and then.
I leave it to lordship. I mean, lordship has got the point. I'm not pressing on it. I'm just simply pointing. I have no choice but to therefore request lordship to see the file. And therefore, lordship, if lordship is, since he has argued that as a submission, then lordship may, as my counter submission, record that yes, this would be clear from the file. Of course, then of course the law of contempt will take over. I'm only placing for that recording that submission there.
Yes, for that part, we'll just.
Just one aspect, Malak, as an officer of the court, Malak, the idea is not, Malak, to send anyone to jail or anything.
It's okay, but we'll have to rise.
Yes. What I'm saying is, Malak, your lordships may, if your lordships decide, Malak, can direct, Malak, the contemptors to comply within a time frame. Failing which, Malak, they should appear before this court, Malak, to face the punishment.
But Mr.
I'm grateful for appreciation.
Grateful, Lordship.
Mr. A. Chaudhary, assisted by Mr. Vora, then we come to the petitioner. As well as Mr. M. Kohli, Lanai Senior Counsel, assisted by, just give the names, we'll record that. Mr. Dipankar, the Senior Government Advocate, Mr. N. Krita, Government Advocate, and other, Ankit Roy and N. Menon. For the respondent. Submissions are concluded. List again on. The next date we'll just deliberate and give.
Sorry.
The next date it will be online because the next week is the only working week. We'll be on vacations thereafter, so we'll just deliberate on the next date and then.
Very good.
As it suits. Deeply obliged to Lordship and
There's
Ladyship.
most likelihood of the matter being spilled over after vacation. Because we'll not be able to give a date right now.
In case it suits Lordship and Ladyship and also my friend, 21st, because 20th in Gauhati, we already have several matters.
There are consequential orders in contempt which we have to pass.
Yes, definitely.
So, for that reason, because if we take a view, then perhaps we'll have to
Summon them. Very important.
post a date for framing of charge that is required in our.
But rule 10 says, my lordships can do it on the basis of the evidence.
No, because you see, we both are distant apart. So we don't.
Yes,
know
yes, yes.
We can have a meeting of mind on that.
Okay.
So the next date we'll give after that. If
Right.
it is after vacation, you are saying 21st. Mr. Kohli,
Lordship. I'm in your hands. I was only saying for 21st, but I leave it to you. Whatever suits
it's
the
just
convenience.
okay, but we are not fixing a date right now, but you will get it.
We'll wait for it, Lordship.
It will be reported.
Very grateful, madam.
Right now, we are unable to give a date without.
No problem. As
without
it
looking at our roster.
Yes.
But today again, it's a difficult day for me in the bench. I have 4 bench today.
Oh,
This is the second one.
Second bench, which is, we have 2 more, so it's very difficult situation.
Very grateful for present here.
grateful, Lordship. Lady.
Division bench for delivery of order. Item 1. IA criminal 98/24.
So first at Itanagar, her ladyship is muted. Please switch on the speaker.
After completion of inquiry, the report and the TCR shall be returned back to this court. Item number 2
Item
and 3.
2 with 3.
My lord, I'm appearing on behalf of R. Taku. Conducting counsel having personal difficulties, he could not appear today. The case is fixed for medical report of applicant. However, we have to draw the IN number 28, 2026, because case has already fixed on 23 July. TCR and paper book is ready for final argument, my lord. Therefore, we do not need this bail.
Not my fix is for hearing, Your Lordship. Since the paper book is.
DB?
Yes.
With, sir will say, I think, Lordship will say.
But notice on respond number 2 is not yet served.
Yes, my lord. We have not taken steps.
Yes, so. Okay, this is 302. 302. Sister, we don't think in 302 it is required to be served on the respond.
Not
number-
required to be served. 302 not required to be served. But
Oh, yeah, it is.
he, on the ground of non-service of notice, I think he is asking for adjournment.
Yes, my lord. The case is already fixed for 23rd of July, so there is no needed of bail.
We've asked for a medical report.
My lord.
We had asked for a medical report.
My lord, we want to withdraw this IN number 28 of 2026.
Okay, you want to withdraw it? Okay.
Yes, my lord.
Okay. Upon instructions, Mr.
A.
Yes,
Bonia?
sir. Yes,
Donald.
I'll pass an order.
Okay, okay,
I don't have the record with me at present.
okay,
The records are not with me.
okay,
I'll trace out the record and pass an order.
okay. Yes, system. Okay, we'll pass on orders and you'll get it uploaded tomorrow.
Record is not with us, so I didn't get.
Okay. Okay, sister.
I will pass an order.
Put on your speaker. We are not hearing you.
My lord. The petitioner filed a written statement in the tribunal, Your Lordship. Written statement is at page 44, Your Lordship, and number 15. The petition reduced 5 witnesses, Your Lordship, including one official witness. The name of the grandparents of the petitioner appeared in the Bhutan list of 1965, 1970. Name of father of the petitioner appeared in the Bhutan list of 2000, 1977, Your Lordship. There was 2 shifting, Your Lordship. Parents. One in 1977 from village Adagunda to village Bogoraguri, then village Adagunda to Maharipa, in 2009. No, my lord. 1977, my father's name appeared in the voter of 1977 for the first time at the age of 24. You'll have to answer number 77.
What about your grandfather then?
Grandmother, name of grandmother appeared in 1970 and grandfather's name appeared in 1965.
77, why your grandfather's name is not there along with your father?
Yeah, alone. It is not the body.
77 is only Abdul Hussain, son of Hussain.
Yes. In 1977, for the first time, the name of father came in.
Again, steps will be taken. As all the respondents are represented. Next, just the matter for hearing. In the week commencing 17/8/2026. Before that, prayer was posed by the learned standing counsel for the border and active matters. Concerning the projection made in the repetition. Period of this 5,000 with the satisfaction of SP border, which place?
No,
No. Petitioner shall cause protection certificate with same order.
habla ya.
Upgraded item 10 for hearing.
My lord, this application was earlier filed in 17 by the petitioners, my lord, challenging the order passed by the tribunal. Dated 25/9/17, in which by which the tribunal has rejected the prayer, referred against the petitioners, my lord, and held them to be foreigners, holding that they have failed to prove that they are citizens, hence it was rejected. Against that, my lord, this writ was filed, and challenging said order, my lord, containing that the petitioners are citizens and the learned tribunal has not considered the materials based on the records, and have illegally held that they are not citizens.
Yes.
The petitioner at page 38 below of the writ petition have filed a religious statement giving the documents and refer to the documents and other materials, my lord, including voters list and the land documents to show that his parents and grandparents were in India prior to 66. He submitted his written deposition also and condemned that details of the facts, my lord. But the learned tribunal have, or learned honorable high court will, by after hearing the matter and Hello. Yes. শ্রীযুক্ত এডি হাকিবর, referring to the officer Milad. হাকিবর ইথার 24/5/33 তারিখৰ হুকুমতে তাবত পাত্তা সহ শেখৰ মনু শেখৰ ফলত
This seem to be Kong.
No. No, this is not Kong. It's the Akar. সূত্রে বরণ শেখর নামে নামজারি হয়। Some manner writing শেখর ফলত হিন্দু ছিল। Maybe Khori Sutre. Khori Sutre. So sell, by sell.
It's home to even at
3833 and it is undersigned on 4833. Jaw. So between jaw. Yes, this is the,
This flag is of DW2.
Yes.
One page earlier, you will find the evidence of DW1.
yes,
There 1 or 2 pages is DW1. Now, DW1 did not come, he is the proceeding, he did not come and exhibit any document. Therefore, obviously, there would be no cross-examination on document or no questions by the tribunal. Now, DW2, who is a neighbor, he comes and exhibits all the documents. So that is not the way to do it. Therefore, the proceeding does not take the responsibility of the documents. After one page, you will find in the deposition, third page from here.
yes,
Then you will
that
find
is true,
the,
because he said that he knows all the পৰিয়ালৰ আৰু মোৰ পৰিয়ালৰ লোৱা হয়। লোৱা হয়।
I'll tell you, Mr. Salia,
Hmm.
you see that I am the son of A. The question is, do I have a personal knowledge? Answer is no. Everybody told me that I am the son of A. That is how I know it, because that time I did not have my knowledge of who gave me the birth. So therefore, you see, so far as I am concerned,
Maybe to be frank enough, maybe this was a lapse on the part of the council.
but it destroys the entire case.
I also noted it at the beginning. But this is also evidence, this is supporting the evidence of
No,
the
but he proves the document, so he cannot be asked anything. How did he get the document? You see, here the problem is that he adduces the evidence, but so far as the father is concerned, there's no document of prior to 1971. Therefore, under the requirement of the Citizenship Act, it's not only the duty to prove it, but also
No, the requirement is not, I am to show, prior to 66 or 71, I am in India.
no, not
His
only
parents
that,
are in India.
not only that. It's
That
also
way the
requirement of
given, so to give, you know,
6A3 of the 6A3 of the Citizenship Act.
no, that's- Six A.
So you see 6A3,
Yes,
not only 2 is required to be shown, but 3 is also required to be shown that 6B, 3B has since the date of his entry into Assam has ordinarily a resident of Assam. This is the 2 points where we are not satisfied. Mr. Salia, we will hear you after vacation. We prepared on that point because 6A,
yes,
C if that continues, the continuous stay is not shown. And the link between the link between the father and the grandfather is broken. Continuity we are not finding. So these are the.
No, another act, Milord, what is required to be proved is that they were in India before 71
But that's
or
not,
66.
but it's not available.
Hmm.
That is not available.
No, 66 is there, Milord. 66, up to 66, the voters list are there. Earlier court also found that. They only said that the earlier DB, earlier also found that, earlier DB also found that. They also said, only said that his parents, his grandparents, whether they are in India or not, that is not missing. That is
No, you see, for that, there is no document at all.
all that, Milord, I have written that document, Milord, that
apart-
document.
Apart from that, Jamabandi.
Government is, because if one has land,
Merely shows.
because we are not here to decide the title of the
No,
property.
no. But you see,
Only
you are
to
trying to
show
his
that
existence.
something was there.
You want to show his existence.
Yes,
For
land
doing-
was there, because if land is in my name, Milord, land has to be there, Milord. Otherwise, how can that be mutated
You
in
see,
my name?
that's why we don't have those documents. How it was
Anyway.
mutated, we don't know.
Anyway,
See, why was the mutation, nowhere it has been stated in the pleadings as to the date of death. That's not there.
they say 60. 60. In the appearance also it is written.
But
In the evidence also it is written.
in 60, the grandfather died.
Yes,
Before
yes.
60.
Then come to your Jamabandi. What is the date of collection?
No, his great grandfather, Baron said, not Saharan.
So when did
Saharan's father is Baron said. So in 33, Baron Sheikh's name was mutated.
and therefore father and the grandfather, how is it connected? The father of the petitioner and the grandfather, how are they connected? What is the document to link them?
Link is your, this,
Will tell you, this link is the second Jamabandi.
Exhibit in yours.
This link is the second Jamabandi, but there is no link between the first Jamabandi and the second Jamabandi.
yes,
Here the date of correction when it came, we don't know. You see, we are not determining the title.
this is an original.
We are not determining the title. We are just trying to see the connectivity. You see, the argument made all throughout is that it is common for a person from Mohammedan community to have multiple names. Even Supreme Court takes note of that.
But
Now,
in this case, names are not multiple.
No,
They are
not that.
all,
So therefore, you
generally
see,
it is there.
the person who is being, you are claiming as your father, whether he is your father or not your father, that is the issue.
That evidence they have not produced, no.
Just not there.
No, the other side has not produced any evidence that he is not my father.
No, negative can't be proved. Negative, nobody can prove a
They
negative.
made an inquiry. Only after that, Milord. And there they also said that he is my father. If they admit
But
that
we have,
Tahir Ali is my father,
Mr. Chalia,
then no
that-
further proof is necessary.
no.
If I show
That
some
we
document,
have a lot
Milord,
of judgments in favor of the state which says that merely in the notice or in the inquiry, form of inquiry, writing of a name of father would not create a relationship as a father. That has to be proved by cogent and admissible evidence. That is not one, but there are several such judgments of this court. Therefore, not only we are trying to have the person connected, but the evidence, you see, you say that the land document is there. But the original allotment orders which create the title, those are not there. So let us assume at
those
33.
will be difficult.
It's okay.
33,
It's okay, we are not doubting it. But you see,
33 and 26.
1933 is there.
Almost the century there.
Since 33, there is not a single land revenue payment receipt or anything to show that this is the person who is holding a land. And then certified, the Jamavanti is only a certified copy.
Literally,
Yes.
it is a permanent
So if-
document, so
if I
from
can-
here,
No, if I
it
can,
proves the title, proves the
if I have connections,
contents of the document.
Mr. Salia, if I have connections, your houses, your land's certified copy can also be Jamavanti can be obtained. So therefore, the Jamavanti is in public domain. It's not necessary that the person producing it will be the owner.
That situation I'll only submit, Milord, will not come in here.
No.
That inquiry, you also will not go back to that.
No, we are not,
33, well, how that entry was made in
No, no.
33,
we are not doubting it.
that will, no.
I have made it very clear, we are not deciding title. We are
No,
not
that's
doubting it.
true, but not,
But what we are wanting is that there should be a connection which can establish you to be the son of your father, and your father is the, if his entry is there in
Son of
1960, then it is complete. So there we find that there's a missing link between you and your father and your grandfather. And coupled with that is the issue where the document was not proved by you. Therefore, you see, the first question is, starts with a doubt. If A is the son of B, why C will come and prove that document? And how will C have access to the land revenue records and other things, Jamavanti to prove it?
no, these documents were already in court. And he, on examination of the papers, he said, because he knew they are just neighbors and I think relatives also.
No, I have many relatives or neighbors around me, but I don't have their land documents. The,
No, land documents were produced by the petitioner no one.
no, that is
No,
filed
he
along
has
with
been
the-
produced along with the written statement.
But in written statement, originals are not filed. So it is only at the evidence stage you will find from the record. That's why we send the records. Therefore, there is a disconnect. That's why we are doubting and we are giving an opportunity next time we can be prepared.
Anyway.
Argument that.
After vacation, Miller.
Mr. Salia, when? Sir, Sunday.
Hearing the traffic.
Hmm.
7.
16 Miller, 16th of July. If it is not inconvenient.
Outside the representative, we then make them study for Salia and it's list. The letter will not be this, you know. What did you say? 16. 7, 20. We will not read it as parted because bench with, we are not very certain.
That system is, I think, discarded it also. Putting it as part of, I think.
We are doing it because you see, yesterday we.
No, it is.
Sorry, we are not.
That's true. I don't think it's so bad.
Item 2 for hearing.
Petitioner Sina Begum, on 15/6/2018, she was declared foreigner from the Honest Tribunal, Kamrup Rural. And after declaring foreigner, they filed the this petition before this Honorable Court, and she reduced 5 evidence in that before the tribunal, and 27 documents exhibited in the tribunal. In the exhibit documents, there are school certificate, Panchayat certificate, land records, Gaubara certificate, and all voter list of our parents and grandparents. Lordship, in her school certificate, page 55, his name
What is the date of the opinion?
Lordship.
What is the date of the opinion?
Date of opinion is 15/6/2018. Judgment is 20.
Judgment
Page number 20.
cannot be 18. My learned senior has taken out. It will be 19.
In the written statement, page 31 to 36.
It seems to be about 50th of February 2019. Page 36. It seems to be filed on 50th of February 2019. Page 36, man. Yes. Affidavit filed in WS, madam.
After that, his father died. In 2015, the year 2015, his father died. 2015. 5 witnesses examined, and 3 are SY group 1, and DW2 her husband, and DW 3 official of this. What is school authority, Panchayat authority, and Giyasuddin Ahmed. DW2, as his husband, husband, Giyasuddin Ahmed. And next is DW3, school authority, for issuing the school certificate. Name is one Sanwar Rahman. He was in LDA of Noyapara High Madrasa. Page 57. Total 5 witnesses examined, and DW 4 count as for on Gaura. Parvesh Ali is a Gaura of matrimonial home. He issued the certificate of certificate. Certain gaps in your feelings. Number one, you don't disclose the names of the family members. You don't give the date of death of your grandfather and father to whom you are connecting. Yes. The documents which you have enclosed in this state petition, which are the exhibited documents, contains some voters list. What is your relationship with the other members whose name appear in the voters list you are not disclosing? The this Congress certificate which contains the state emblem. That was a linked document, not the proof. The disconnect between you and your other relatives, your father and your grandfather. Gaubra used this state emblem. Gaubra statement goes because of page 84. State emblem is there. Device is her father, his name, her name also in the Ramavandi land record, Ramavandi Gobi, page 81. 81. 81. Page 81. Her name, upper musician, her name appear with his brother and the mother also named here. And Mohitur Islam, son of Ghiasuddin Mandal, Hasina Begum, daughter of Ghiasuddin Mandal, and Nurjahan Begum, wife of Ghiasuddin Mandal. You understand, but that's why we're asking you. There's no document, no pleadings, in fact, who's your father and brothers, your siblings. So therefore, when your name comes along with the other people, and we are not proving the relationship, how do we understand, except for your older evidence, that you are your father's daughter?
Contract certificate also, in contract certificate, there is father's name also appear.
That goes, that is the state emblem. Connect. May I have you might have you had a good case, but you are totally damaged. And the nature of evidence that. You see, everywhere, there's a big gap. Number one, your evidence and the evidence of the authorities who issued the certificate is in variance. For example, Gaon Panchayat certificate. The Gaon Panchayat certificate, you say was not collected by you. Then, so far as the Gampura certificate, Gampura comes and says that you took the certificate, whereas you, when you're in your cross-examination, said that you did not collect it. Then there is no pleadings insofar as you are concerned of your siblings. School certificate was issued to you. School certificate is. And this Gaon Panchayat certificate was written as per whatever your mother said. School certificate is clearly mentioned his her father's name. Yes, no. You are referring to which document? School certificate. School certificate. You see, school certificate. Now, this school certificate would not be a good evidence because of the fact that the school register book was produced, but the entries were not exhibited. So therefore, the primary evidence was there before the court, but still the secondary evidence was adduced. An authority also was come to the tribunal and was examined by the tribunal. The LDA came. The damaging part is that in the cross-examination, the witness comes and says on 31/1/2019, Mohammed Ali Mandal retired from his service. Issuing authority was the superintendent of the madrasa, and later on he retired. He was retired, and then you see this Mohammed Ali Mandal, his name would come only when he issues the certificate. Correct. He retired in 31/1/2019. As per your school certificate, you left the school on 31/12/2000. You leave the school in 2000 and you have a certificate of 2019. That goes. See page 55. That is your document. She left the school for the year 2000. But this certificate is you see the entry here. The cross-examination is that on 31/12/2019, this man was already left. So therefore, the certificates, they are perhaps being made by a person after he has retired.
Certificate was issued in 2003. In particular, this
That's okay.
59, 56. Signature of the superintendent took place.
When did the
23
superintendent
12
retire?
2003. Her school certificate was issued.
In 2003, it would not have issued after retirement.
And superintendent of Madrasa, he retired 2000. As per cross-examination of the LDA.
Retired in 2000, how can he issue a certificate in 2003? A retired person coming to the office issuing certificate.
Not sure. Retired person, he retired 2019. 2019. And certificate was issued in 2003. 16 years ago. Page 56. Senior Sub Superintendent, Noyapara, Madrasa, last part of the certificate. And here is mentioned dated Noyapara, 23rd December 2003.
Okay.
And this person was retired in 2019, issuing authority. That means at the time of issuing this certificate, this Mohabbat Ali Mondal was the superintendent of the institute.
You're right. But then no, but then in page 58, she said in 2003, my age was 14 years. I do not know whether the Asana Begum read in the school or not, and whether exhibit 3 issued or not. I know from another person, I carry permission letter of superintendent to not in the school pad. Superintendent name is not written in the permission letter. The permission letter has been given by my superintendent yesterday.
Without it being in the institute, how authority issue this certificate? And that means she was reading the madrasa.
I humble submission, Your Lordship. With the documents of school certificate and land records, this clearly establish the linkage with her father. Gauhati Mandal is her father, and it is clearly mentioned in the school certificate land records. And so, and
This is school certificate, there are judgments of this court. School certificate must be proved along with the school register. Register was brought but never proved.
sometimes school authority forget to carry this.
No,
record.
here it is available. The
Uh,
witness says that she has got it. But your, but that was not exhibited. The person brought was your witness. So if that goes and the Gaon certificate goes, Gaon Panchayat certificate goes, there is no link.
This Kavra is the Kavra of matrimonial area.
It will be, but his evidence is in variance. Your evidence and his evidence is in variance. Then there's the state emblem. Mr. Payne, the case was very wrong, very ineptly handled.
Yes.
Just go through the evidence and history.
I would like to point out only one more thing.
It was. He had a good case. He could have a better evidence, better evidence. Despite your evidence, because of the fact that you said that I collected one document, but your the count said no. Count said she collected, and here he says mother collected.
He contradicts with many occasions, even with regard to land document also not. In her WS, she has written that after the death of the father, being legal here, she inherited this property. And in cross, she has said, I got this property from my father in 2014. Because father, as far as cross examination says, 2015
By will.
by way of gift.
By will.
By way of gift. Dan Hutcho.
Done.
Yes.
But in the English translation, it is written,
In Assamese, it is said Dan, at page 47. Page 57. Exhibit 18, 19, 20, more Kokaduka, Mati Pikura Dolu. Exhibit 24. This is the.
you see page 43, because I had a bit of page 44, 43. As per exhibit 24, my father will mean. I so I will submitted to said will deed in this case. That is the English translation.
Yes.
Exhibit in the page 47, exhibit 24, উল্লেখ থকা মাটিখিনি মোৰ দেউতাই কেনেকৈ পাইছিল?
Page 47, my lord, Assamese version, vernacular. Exhibit 24 মতে মোৰ দেউতাই মোক এক পোৱা মাটি 2014 চনত দিছিল, in 2014. দেউতাই মোক দান পত্ৰ কৰি এই মাটি দিছিল যদিও উক্ত দান পত্ৰখন মই এই গোচৰত জমা দিয়া নাই। So, by way of gift. That means gift. In WS and evidence, she has said, madam, WS, para 12, she has said, page 33. That after the demise of my father, opposite party being the legal heir of late Gauhati Ahmed, this should not be Ahmed. Gauhati Ahmed is his wife, husband. Gauhati Mandal. She has acquired the land property, and accordingly, her name has been mutated in the land record in the revenue village, so and so, so and so, so and so.
But that is with inheritance.
Inheritance.
Promotional inheritance.
Inheritance, according to. And interestingly, my lord, the WS and evidence in affidavit, no disclosure when father died. Only
family is not disclosed.
Yes.
Brother, sister, sibling.
yes, nothing is disclosed. Only in
Cross-examination.
cross-examination she has stated in 2015, and even in 12, para 12, and in evidence in the press, but the mutation that land is mutated, I got in this year, that has not been there. But in cross, he has specifically said, I got this land in 2014. By way of, that is, yes, that is specific.
Lordship, may I say something? Actually, before her father died, her father maybe give one plot of land to her daughter, and without official purpose, without official. But when her father demise, her name automatically inserted in Jamamandi copy with a mutation. But in some areas, some father give some land to her daughter before demise. So but if we will see the page number 82, it clearly mentioned that Asina Begum's name appear after demise his father, clearly mentioned.
So that has been put in one of the, so even in page 57, madam, if you look me kindly continue that reading of that page. Yes, said exhibit 24 খন উল্লেখ কৰা মাটিখিনি মোৰ দেউতাই কেনেকৈ পাইছিল মই সেই সম্পৰ্কে নাজানো, কোনো নথিপত্ৰ নাই, এই গোচৰত জমা দিয়া নাই। এই মাটি গোচৰৰ পৰা SDCৰ অফিচ নামজাৰি হৈছিল। নামজাৰি কৰিবৰ কাৰণে মই মাটিৰ কোনো কাগজ পত্ৰ জমা দিয়া নাই, সকলোখিনি কাম মণ্ডলেই কৰি দিছে। So she has no knowledge. And she has contradicted the page 82 as well as the evidence and the readings what she has stated in evidence and pleadings. Now, if this goes, my lord, then, my lord, the school certificate, as your lordship has seen already, the school certificate, it is clearly said my lord, the DW5 who came before the tribunal. No, not DW5, it is, my lord, the LDA who came. He has not exhibited, my lord, he has neither exhibited the, my lord, issuing register nor the, my lord, admission register. So this is not proof on the basis of any record. He has clearly said that, my lord, the in cross part.
That's why we are seeing, the end of the record, you will find that the school register is available,
Yes,
yet not,
but that was not exhibited.
not exhibited. Or do not even know how to deal with the issue. It is LD, where it is available.
Not annexed. Not annexed.
At the end you will find
Yes,
certificate. The admission register is a photocopy. Photo below. Right. So this is also there with that. After the deposition is that. That tax plan. You send it, I will give it to you. So I will get it. So that PAN card or that card is there, that yellow envelope, near to that.
yes. This is Noyapura Madhya Pradesh,
Yes. 2 pages.
2 pages.
It was available, he said that he, in the cross, he says that he just brought it,
Bro,
but it was not exhibited.
yes. Only in cross, my lord, in fact, in cross, it is brought that he brought it. In absence of those things, my lord,
I both Samisha Lordship, actually, this Hasina Begum is a citizen of India, and there is no doubt when we see these exhibit documents, all documents, voter list, contact certificate, Gauhati certificate, land records, school certificate, this clearly mentioned he is the daughter of the Gauhati Mandal, and Gauhati Mandal is also a citizen of India from 1962 onwards, 2000 till 2010. His name appeared in the voter list.
You had exhibited certain sale dates. Where are those?
Perfect.
Sale dates. You have exhibited two sale dates, 3 or 4 in number.
There is no sale date also.
It's reflected in the order opinion.
Sale date of land records. Okay. Which will get page 55. Just because you said that the school certificate proves, they're just trying to show you something, that school certificate you just showed us is at page 55, correct? Yes. See, the original one is that the original manuscript is photocopy is at page 56, correct? Issued on 2003, 23/12/2003, correct? Yes. Yes. Now come to page 45. What time? 2013 সনদ মই নায়াপাৰা হাই মাদ্ৰাসা স্কুলৰ certificate আনিছিলো। উলিয়াইছিলো, I can't read this properly. উলিয়াইছিলো না আনিছিলো? Page 45. I think উলিয়াইছিলো আনিছিলো, but actually certificate উলাইছিলো। I made a mistake in reading. But the fact is that the document was issued in 2003.
23. If it is 2003, then when you go, they will issue a certificate. You went in 2013 and then issued your certificate 2003, that demolishes everything.
fact, prior to that, my lord, she has said, UNESCO 1998 চনত ক্লাছ 8 নয়াপাৰা হাই মাদ্ৰাছা স্কুলত এডমিশ্যন লওঁ। মই 1999 চনলৈ নয়াপাৰা হাইস্কুল মাদ্ৰাছাত পঢ়িছিলোঁ। But as per the certificate, she read up to 2000, madam, December 2000. But she has said she read up to 1999 চনলৈ নয়াপাৰা হাই মাদ্ৰাছা স্কুলত পঢ়িছিলোঁ।
99.
Yes, but the school certificate
But
shows
certificate 2000.
2000.
This period. No notice.
99, that means
She paid up to December 2000.
2000. 99. Actually, same year, that means 99, 2000.
No, no, 1 year is too much.
And Islam.
And Islam, and also for the petitioner, and also for the respondents. And we can- whatever.
To be spoken to item 1.
None appears on call for the applicant. It's been brought to the notice of the court that the notices on respondent numbers 1 within bracket A to 1 within bracket B, not B, B, was received by the respondent number 1A. So however, due to inadvertence in paragraph 3 of the order dated 27/5/2026, the court had recorded service of notice only on respondent numbers 1A to 1B, which was received by respondent number 1A. Next one. Therefore, the inadvertent error in the order dated 27/5/2026 requires a rectification. Next, accordingly. Paragraph 3 of the order dated 27/5/2026 shall now be read as if the notice on respondent numbers 1A to 1B was received by respondent number 1A. Accordingly, notice is deemed to be duly served on the substituted respondent numbers 1A to 1B. Next one. Accordingly, the reference to respondent numbers 1 within bracket A to 1 within bracket B
appearing in paragraph 7 of the said order, which stands corrected, comma, to be read as respond numbers 1A to 1B. As per order dated 27th, 2026. Internal application has been disposed of.